Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul, and I will guide you on a 3-hour journey through Courtlandia, starting with Judge Oakley.
Last name?
Osley.
Oswald?
Osley.
Osland. Got it.
Osley.
Got it. Yep. All right, Mr. Osley, are you going forward today without an attorney?
Yes, sir.
Let's see what we got.
Excuse me. When I was here last time, you told me I didn't really need my attorney.
No, I never would have told you don't need an attorney. I would have said you don't have to have an attorney, but you're always welcome to have one. So it's up to you. We got attorneys here to talk to if you want to talk to one.
I should be fine.
Okay.
It's just a review today, right?
I don't know. I got to look at it. Yeah. You're just supposed to tell me what's going on. Yeah. So what's going on?
I'm just working.
Where are you working?
I'm actually working at a new job right now.
Where at?
It's
What do they do? What do they do?
Picking up parts.
Okay.
My job.
Full time?
Yeah, I'm full time.
What are they paying you?
10 hours every day.
Okay. Okay.
It's really 6 days a week, but sometimes I go overtime.
All right.
Overtime going.
So you're getting at least 40 hours.
Yep, I'm doing.
Okay. All right. You're still living out in Detroit?
Yep.
Okay. But they're only paying you $15 an hour? Before you leave the building, have you talked to Avery Taylor yet?
No. And one more thing.
Yeah.
Please write me something saying that I had to come here because my manager.
Yeah, we'll give you some documentation. You're in court. Sure. Matter of fact, you can get that from Mr. Taylor.
Okay, thank you.
Go downstairs, talk to Mr. Taylor about jobs. He knows some jobs in our area that are paying better than $15 an hour. Don't have any skilled labor needs. Just they need people to show up and do what they're told. All right. What else going on?
Nothing much, sir. I'm just taking care of my 2 kids and going to work. I'm still working on in school right now, but with the full time.
Where are you thinking you're gonna
go? For school?
School.
Oh yeah, I want to go to school in Atlanta with my mom. She lives in Atlanta.
Okay.
Probably Georgia.
What's a long-term plan school-wise?
For what I want to do?
Yeah. What do you want to go to school for?
I want to go for trading. I want to take a trade.
What are you thinking?
Factory.
Okay.
Like that.
Okay.
Anything I can really get into.
All right. Talk to Mr. Taylor about that too. Tell him what your long-term plans are.
I'm still thinking of some too.
Okay. But here's the problem. How old are you?
22.
Yeah. Dude, listen to an old man. You got to start doing, because you're going to say, yeah, whatever. But I'm telling you, I've been doing this a long time. If you're just thinking about going to school, 2 years from now, you'll still be thinking about going to school. 5 years from now, you'll still be thinking about going to school. Get something started.
I know.
Right? Get something started. And at your age, you're 22, you got unlimited energy, right? You can do a 40-hour job and do a school program. And a lot of the trade schools will have flexible schedules. And the kind of jobs you're getting, right? It's like labor, right? So if you're getting $16 an hour here and you can get $16 an hour here, but this one, the schedule will let you go to school, then switch jobs, because you're not working career jobs right now. You're just working, make some money. Okay. So don't let the temporary $15 an hour jobs stop your long-term plans of going to school. Does that make sense? All right. So go down and talk to Avery. Tell him you got to have something that shows you were here today, and we'll see you next time.
I appreciate you.
All right. Keep working. Beal, we ready? Good morning, counsel.
Morning, Your Honor. David Lechner, P number 67994. No, you're fine. On behalf of Cynthia, who's approaching.
Good morning, ma'am.
Morning.
So, Mr. Lechner, you're here for sentencing. Have you looked at the report and recommendation?
I have, Your Honor.
And you've gone over it with your client?
I have.
Okay. I've read your memorandum.
Okay, well,
Nice memorandum. So,
and this is, just to refresh the court's
Yeah.
recollection, this is the second sentencing because we were here a while ago.
Yep.
And based on my memorandum, you advised us to kick the can down the road so my client could get a substance abuse
Yep.
evaluation, which she did.
awesome.
And has the court seen that?
I have not.
Well, I
didn't.
sent
Okay.
it to probation, but I have a copy right here for you.
Well, I probably got it up here then. Who's it from?
It's from Julia DuPont Moshe. done on,
I do not have it. Let me see your copy. I'm a quick reader.
may I approach?
Yeah. Thank you. Give me just a second. All right, counsel. Anything else you want to add?
Yes, thank you, Your Honor. So, per the more involved alcohol, substance abuse screening, Ms. Beal has a low probability for substance abuse disorder. It suggested that she complete the victim's impact panel.
I saw that.
And I have no problem with that
Okay.
whatsoever. I think most people should complete the victim's impact.
Okay.
But I looked at the recommendation from probation but for amending it from 6 months probation to 3 months, it's essentially the same. I would ask the court to consider again, victim's impact panel costs and fines, in that be it. Ms. Beal is 70 years old. She's not in the best of health. She suffered a closed head injury a number of years ago. I don't think she can physically complete court-ordered work program.
Right.
And it's not that she made a mistake. She's truly remorseful for that. She's not going to do it again. In looking at the alcohol screening, she's under the court order not to consume alcohol right now, but she's not going to, she doesn't think she's going to consume alcohol again in the future.
Right.
She's done.
How long will it take her to do the impact panel?
I don't know.
Think she can get it done within 30 days?
I would think so. As long as she can schedule it through probation, I would think.
Yes? That lady says yes.
Yeah, that's her daughter. So she'll.
Okay. All right. Anything else?
No, Your Honor.
Okay. Ma'am, you don't have to tell me anything, but if you want to, this is a chance for you to talk. Anything you want to say?
Sorry.
Okay, that'll work. Okay. All right. Ready for sentencing?
Yes, sir.
All right. I'm just going to do fines and costs, and I'm going to require the impact panel documentation that the impact panel has been complete 30 days. So obviously, Mr. Lechner, for whatever scheduling reasons you can't get that done, then contact us and we'll give you some more time to get that done.
Thank you, sir.
All right. Fines and costs are $1,300. Can you pay that today, ma'am?
Yes.
You got the impact weekend, Heather, or impact panel? Counsel, any clarification?
No, Your Honor.
All right. You two have a great day.
Thank you. You as well.
Thank you.
You're welcome, ma'am. Counsel, we ready on Abraham? Good morning, Ms. Belcher.
Morning, Your Honor. Anna Belcher on behalf of Mr. Abraham. Sir, will you please state your name for the record?
Joseph Abraham.
Good morning.
Your Honor, today is the date and time set for sentencing. We have reviewed the sentence report. Do find it to be factually accurate. We have no additions, corrections, or deletions to make to the body of the report.
Okay. All right. Tell me what Good Shepherd Operator is all about.
It's a nursing home, skilled nursing.
Okay. Okay.
I'm an administrator.
Okay. All right. Long time administrator.
Yes.
Yeah. Okay. All right. All right. Nothing to add?
Your Honor, I do have allocution when the court's ready.
Go ahead.
Your Honor, the recommendation is for a period of probation with a number of different conditions. What we're asking the court to consider in Mr. Abraham's case is fines and costs. I know the court is familiar with the change in laws that occurred with first-time drunk driving offenses being considered a non-serious misdemeanor where the presumption is no jail, no probation. In this particular situation, I think Mr. Abraham is the perfect candidate for fines and costs. He lives 2.5 hours away in Ohio, so oversight would be challenging. He's 64 years old. He has absolutely no criminal history. This is his very first contact with the criminal justice system. As it relates to the underlying incident, Your Honor, Mr. Abraham was here for a funeral with a relative, had too much to drink, and did exactly what we would want someone to do: pull over when he realized he had too much. The unfortunate part was how he pulled over was not proper, which led to his contact with the police. The firearm that was involved in this case was a legally purchased firearm by Mr. Abraham. The court may be aware that the open carry laws and carrying concealed laws in Ohio are very different from Michigan. Mr. Abraham at one point did have a valid CPL. However, when the laws changed and that was no longer required in the state that he lived in, he did not renew his CPL. He's gun education classes and did provide that verification to me. So this was a legally purchased firearm that was involved. Looking at his scoring on, I believe your court uses the ACE assessment, he's extremely low. And Your Honor, I think all of those reasons would make Mr. Abraham a perfect candidate for fines and costs in this situation.
I'll be honest, one of the things I looked at is the fact that he violated bond, which is always a problem for us.
Your Honor, we did not have a bond violation hearing.
No, we didn't. But he self-reported at his interview and said that he had used after he was told at arraignment not to. He was arraigned on 4/13. Judge Patton said no use of mood-altering substances. And at his pre-sentence investigation, he said that he had consumed alcohol approximately 1 day per week from age 21 until 5 days prior to the interview, which would have been May 23rd. So 5 or 6 weeks to his conditional bond.
I did not realize that that was the stipulation. Mind altering.
It wasn't a stipulation, it was a court order. Stipulation means we're in agreement. Court ordered is you do what we tell you or there's consequences.
And Your Honor, in Mr. Abraham's case, not making excuses, but he is one of my clients who is probably the most on top of and diligent clients that I have. He takes this very seriously, to the point to where he over communicates with me and he is concerned about everything.
Right.
The court was going to allow him to appear over Zoom given this today, but he wanted to drive here. That's how serious he took this. As it relates to his initial arraignment, Your Honor, I didn't want to get into this with the court, but I think it's important if the court's considering the initial contact. Mr. Abraham's family hired an attorney that was not me to be present for the arraignment. They took a large sum of money from Mr. Abraham and never appeared for the arraignment. So then he had court-appointed counsel that assisted him, who was very capable, Mr. Kaplan.
Yep.
And then when Mr. Abraham was released, after having no contact with the attorney that was paid for, they tried to extort even more money from Mr. Abraham, lied about the charges. So Mr. Abraham has been through probably one of what I would consider gives the attorneys the worst reputation. And that was his very first contact.
Yeah.
So had he been with me, I think I would have made those terms extremely clear to Mr. Abraham about what is
I
expected.
have no doubt you would.
I would have, Judge. So once I got in the case and we went over those terms and conditions, Mr. Abraham did not have any future violations.
Are you done beating me up yet?
Of course, Judge.
I'll tell you what I'll do. I'll adjourn sentencing, have him go through a full-blown evaluation, and if the evaluation comes through, no need for further education, I'll do fines and costs and be done with it.
Yes, Your Honor.
Deal?
Yes.
You want to just get with her and pick a new date, or you know what your next one is?
September 24th in the afternoon or October 15th in the morning.
September 24th, enough time?
I think it should be enough.
Well, let's run that one with the idea that you call us and tell us you got to do it over.
Any issues that I run into with the screen fence one,
Okay.
notify the court, we can adjourn the day.
All right. Heather, you got that?
What was the time on September 24th, Your Honor?
I don't know. I don't listen very much.
1 p.m.?
What was the date, Emily? September what?
9/24.
1 p.m.?
Correct.
Okay, we'll take another look at this after we see your evaluation.
Thank you, Your
All
Honor.
right.
I allowed The provider, or is there?
Yeah, I trust the fact that you're not going to do some fly by night just to convince me what you want to do. You're going to get legit.
Thank you.
Yeah. All right. We'll see you again. And we'll Zoom you if you want to.
That's up to you.
But I mean, I'd rather have you in person, but
I'll be in person.
I'm not gonna treat you any differently if you're on the camera,
I'll be in person.
unless I yell at you.
Okay.
Okay.
I,
All right.
thank
Have a good day.
Thank you, Your Honor.
Good morning once again, everybody. It is TCF Live on a Friday Eve, also known as a Thursday. It's good to have you all here with me this morning. Thanks so much for joining. Barbara, thank you for the $5 super chat, calling out the new links that we have. Yes, we have totally reimagined tcfhub.com. Do check it out if you have a moment. Everything TCF, pretty much everything except Court Watch. That's its own standalone thing. But pretty much everything else TCF all in one place. Our store, our talent list, my writing, everything all in one place. So do check that out. By the way, not mods, sidebar participants, do me a favor and check the sidebar chat backstage, please, because I have something I need an answer to, if you would be so kind. Let's go to Lake County, Ohio. Judge O'Donnell.
Seated. Well,
Thank you, Your Honor. We're here today in the state of Ohio versus Curtis Harris, case number 26CR637. The defendant is present with counsel Brett Jordan. We're here today for a sentencing hearing. We were last before you on July 8th. At that time, the defendant pled guilty to count 1 and count 3, those being trafficking in cocaine, the first a felony of the 5th degree, the second a felony of the 3rd degree, both with attached forfeiture specifications. During that hearing, a pre-sentence report was ordered. That report has since been completed. There is a joint recommendation in this case for 40 months of prison. Thank you.
Mr. Jordan. Thank you kindly, Your Honor. That is, at this time, I'd respectfully request that this honorable court accept our recommendation of 40 months. As you can see from the PSI report, my client has accepted his responsibilities and his accountability for his actions. He knows that he has not only hurt the community, but more importantly, he's also hurt his family. He has children that he needs to support, and he will unable to do that now, Judge. So we'd ask that you accept the recommendation and sentence him to 40 months. Thank you. Mr. Harris, what do you want to tell me before I sentence you?
Your Honor, I just come before you to take accountability of my actions due to my lack of judgment on what I was facing in the past. Me being in jail for 4 months, I could say I'm no longer that type of man. As a father, I looked in the mirror and I felt like I not disrespect only myself, but my kid, because he constantly asking me, Daddy, when you coming home? Daddy, where you at? And it's like he's 3 years old. I'm not there to potty train him, see him be a potty train. This all had hindered me from a long shot, me thinking, taking a shortcut, but really I didn't.
Hell, you've been doing this for 15 years.
I understand that.
The same thing over and over and over for 15 years.
I understand that, Your Honor. Just through my upbringing as me coming up as a kid, I seen things that I thought was the right way, and it's not the right way. And I'm just being honest. It's not the right way going about things like that. And I'm tired. Not only if I'm tired, my family tired. I just want peace in life. And then that's not the life that's giving me peace, because I constantly keep going through the same thing. It's like insanity. It's like I'm being insane. I'm constantly going through the same thing, Your Honor. And I'm tired. And I'm truthful, this coming from my heart. I'm really tired.
Well, then you ought to stop doing this shit.
Yeah, you're right. And I should stop doing it. That's what my next goal is to do, regardless of how the outcome come with this.
Why are you being such a pain in the ass over here?
Where?
At the jail.
In the jail?
Yeah. You got a number of lockdowns.
Yeah, they locked me down the one time for saying that I asked the CO, was he eating chips? Because I just asked him, I said, was you eating chips? And he said he locked me down. That was my first lockdown. My second lockdown, I went to church, and I came out of church, and they said that we wasn't supposed to leave out of church. and I didn't know. So they locked me down for that. Then my third lockdown is because somebody put a tablet in my room, and when they put the tablet in their room and they came to do count, I got locked down for that. I'm not making no excuses because at the end of the day, it was my actions that caused me to being in that, but I'm really not like a violent person. If I'm respectful, I'm disrespecting myself and my family.
Well, that and you're putting a lot of poison out on the street, right? Right?
Yeah, yes. That's what got me here. And due to whatever consequence that I have in front of me, I know in my heart I'm getting too old for this. There's no excuse for it. I'm getting too old for it. I'm about to be 35 years old. In 5 more years, I'll be 40. And I ain't trying to be 40 years old talking to my son through a jail. Or, God forbid, the graveyard. I don't want to raise my kid like that. I don't want to be the role model being like that, putting that in front of him like it was in front of me.
Well,
when I was growing up.
that's great. Then you ought to stop doing this shit. When you get
Correct.
out, you're going to go. When you get out, you probably ought to do something different because you ain't very good at this drug dealing stuff.
Yeah, you're correct. You're absolutely correct about that because it's a constant thing. And I had a job. I was going through temp agencies. It's just that I get laid off. And then my back be pinned against the wall where I think going about it that way ain't the right way. And you're absolutely right.
All right, Ms. Bell,
Thank you, Your Honor. The state is asking that you adopt the
you can have a seat.
the joint recommendation for 40 months in prison on this case. The defendant has priors for trafficking. He was on community control for trafficking when this offense happened. He was under indictment for trafficking when this had happened. It's clear in his last case he got 39 months in prison for trafficking. It's clear that there is a problem here, and prison is really the only way forward. Thank you.
All right, I've reviewed the pre-sentence report and the past pre-sentence report, and the letters in support. Listen to Mr. Harris, listen to counsel, considered all the relevant statutory factors. I'm going to adopt the joint recommendation. I'm going to sentence you to 4 months on count 1 and 36 months on count 3 for a total of 40 months, which is a joint recommendation of counsel. Credit for 109 days. The items subject to forfeiture are forfeited to the state. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate, the parole authority could send you back to prison for up to 9 months for each violation. Up to 1/2 of my sentence. If it's a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Remaining charges are dismissed. Anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Jordan?
Nothing further, Your Honor. We thank you.
All right.
Hold on. Okay. My mic was like not telling me whether or not I was live and whether or not the mic was hot, but apparently it is. Good morning once again, everybody. It's TCF Live on a Friday Eve. Let's do this. Let's go back up to Michigan. Judge McNally.
Please. Yes, ma'am. Your name?
Elmore.
Why? What is going on here? I told you if you didn't have the money to call the court, I'd give you an extension, right?
Oh,
When did I make it due? You were supposed to pay that day.
I know.
Why didn't
If
you?
you have the money today, I wanted a payment plan because I wasn't working at the time, but I actually, I'm done with nursing school.
Hang on, slow down. Hang on. Why'd you just leave? You told me you were going to pay it that day, didn't you?
Yes.
Wait a minute. Slow down. Slow
I
down,
apologize.
please. Why would you just leave?
When I had went up to the desk, I thought that someone was going to be able to send me the money at the
Did you
time.
come back into the courtroom and say, Judge, I don't have the money?
No,
Why not?
I didn't even know I could do that. I
Thought just leaving was the best. You have it all now, right?
thought,
You have it all now, right?
Not all of it, that's what I'm saying, I could do a payment plan or I could put some money.
Listen. This was back in April. What is going on here?
Well,
I want to know what's going on. Why would you do this? You're a nurse?
well, now. at the
Wait a minute,
school.
wait, you're a nurse.
Yeah,
You don't work as a cashier someplace. You're a nurse. Be responsible, will you please?
yes. Yes. But I'm done with school now, so.
Well, I'm glad you're done with school and I'm glad you came with some money. I hope you came with a lot of it. But the point is that you cannot do what you just did.
Okay,
How much do you have today?
I brought 150 with.
That
me.
isn't a lot. You owe 405.
That's what I'm saying, can I do a payment plan or is it possible? Like I said, I start work on the 27th, so I feel like it was I get my first paycheck.
Man. How old? Yeah.
38,
And that's your child?
yes.
Good looking kid.
He's-
Yeah, how old is he?
He is 3.
So you have to set an example for him, right?
Yes.
This was not a good example to set.
No,
When do you start your work?
27,
Of this month.
yes.
You pay 150 now, you pay 50 per week. I'll give you some leeway time. You'll start that on September the 18th. Now listen very carefully. You don't have the money, you call the court, you can either come in, Your Honor, before the due date, or I'll give you an extension, but you cannot ignore a court like this. Do we understand one another? So if you don't have the money, what are you gonna do?
I'm back in here.
Honor before the due date at 8:30, right?
Yes,
Or you can call. It's easier if you know how to use Zoom. They'll put you on Zoom. I'll give you an extension, but please don't do that again. Okay?
well,
I gotta be mean then. I don't want to be mean. I could send you to jail today and I don't want to do that. Get out of here before I change my
Judge,
mind. Good luck. Patrick, Myron, come on.
Judge,
Yes.
I'm sorry, it's something interrupted in there. It was 150 today, and then what was she paying?
50 a week starting September 18th.
Thank you.
Where's Mr. Schwartz? You're not on Zoom, are you, Mr. Schwartz? Mr. Schwartz.
He is.
Why is he
there.
on Zoom? He can't do that. Did I tell him he could do that? Patrick Myron Kimaki, 26R514-566. Your name?
Patrick Myron.
You're charged with anti-blight violation. You have the right to a lawyer. Do you want one? Okay. On July 24 of 26, it is alleged that you committed an anti-blight violation at or near 21744 Washington Street in Rockwood. They say tree branches were still in the neighbor's yard. They must have fallen from your property allegedly, and you were sent a letter to clean it up. That is a misdemeanor. It is punishable by up to 500 fines, not to lose jail costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that? You have a right to a lawyer. I'm going to tell you again. Do you want a lawyer?
Yes.
You want one now?
Yeah, yes, because,
You just told me you didn't want
Well,
one. Wait, hang on. I just want to make sure I didn't understand you. Did you not tell me that you didn't want a lawyer?
well, I was here for something else.
What'd you think you were here for? Do you have another case pending in the
Well,
court?
not the blanket, so I didn't know if it was.
So you want a lawyer? If you want a lawyer, that's fine, but hang on, slow down. You are entitled to a lawyer for arraignment. You said you waived your right to a lawyer.
Yeah, I didn't know.
Let me finish. Do I look like the kind of guy that wants to be interrupted? I'm serious. Just give me a second. I'm going to enact the Oakley plea for you. Do you have the money to hire your own lawyer? Where do you work? There's hundreds of car dealerships. Where do you work?
Taylor Chevrolet,
What do you do there?
sell cars.
You make enough money to hire your own lawyer? Come on. This isn't free lawyer day. You get one at the arraignment. So if you want to hire a lawyer, I'll give you a lawyer. I'm going to give you a personal bond, $100. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Did you tell me how much money you make, or do you want to fill out a petition for a court-appointed lawyer?
How much is it so you be done with this?
You gotta get that taken care of.
Yeah, I gotta take care
We'll
of
go, maybe if you talk, but here's what I'm gonna suggest you do. If you think it's taken care of, go talk to the prosecutor. If you want to, or you can go hire your own lawyer. Well, let me finish. Maybe he'll work with you if you've taken care of it. If you have, but you don't have to do that. If you want a lawyer, you're gonna have to fill out a petition for one or go hire. I'm not trying to make it bigger than it is, but you're entitled to a free lawyer, not through my rules. I don't necessarily think this is the greatest that we have going on, but you're entitled to a free lawyer under MIDC on your first appearance, but you waived your right to a lawyer. I got done with the arraignment. I'm saying you want one. So if you want one, I'll let you go hire one, or I'll give you an adjournment. You can fill out a petition for one, or you can go talk to the prosecutor on this and see if you can work something out. If you can't, then you still could hire one. Daryl, what do you want to do?
toss it up front.
Okay, so you understand right now you're not going to have a lawyer. Okay, good enough. Good luck. Mr. Schwartz, why aren't you here? Give me that file.
I thought I got it. I thought I could do it by Zoom. I was at the dentist all morning too.
You can't do that by Zoom. Not on a case like this. You got a serious issue with Mr. Eschenroder. We had 3 of these, or I don't know what happened on the other case. I need the Eschenroder file, please.
Can we just adjourn it till next Thursday, Your Honor?
Yeah, but you got to appear in person.
I'll
The
be
rule
there.
is you either got to have your client in your office, or you've got.
He doesn't have a license. It's almost impossible for him to get around. He's
Well, I
really
get
having a
it.
hard time.
All right. Well, I'll adjourn it for you, but what happened with that case? This is People Against Tash. Come on up here, Mr. Eschenroder, 263-06-933. What happened with that case in Monroe? State your appearance again.
Seymour Schwartz, Your Honor, appearing on behalf of the defendant. Monroe,
Go ahead.
I haven't received any notice about it yet. So I'm unaware. I think it's pending.
Have you been to court on that yet?
Oh, sorry.
I'll adjourn the sentence. Give me a new date next week sometime, Heather. There's no victim here. We can do it any day.
Can we do it on Wednesday?
I'll do it whenever you want, Mr. Schwartz. We are so accommodating here at the 33rd. You should know that by now.
It's one of my favorite courts.
August 26th, Heather?
Yep, we can do that.
What time you want to be here, Mr. Schwartz? I want to make it convenient for everybody.
First thing in the morning, Judge.
8:30 you can be here?
8:30.
Is your client? I'm worried about your client here. This is damning. He had 1 in 25. He had this one, and he's got another one pending, apparently, or at least was arrested on.
Well, he's
So don't be
seems to
surprised if I'm telling him to go sit in the back room for a while.
He's learning his lesson as a result of the
That's good, and he's a nice
difficult
kid,
things he
but he's
has
still
to-
got a consequence to pay when you got 2 and another one pending. We'll see what happens on the other one. I'll see you next week.
Thanks.
Have a
See you,
good
Judge.
day. Go down
You
the hall,
too.
get your new notice.
Thank
You better
you.
stay clean. You're on a very, 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 very short leash with me.
Good morning once again, everybody. It is TCF Live on a Thursday. It is good to have you with me here today. A special welcome to April Searing in the chat this morning. I call her out because, number one, she's got a pretty good channel. You should go check it out. She does a night show, one of the few times where we're not live here. Her audience there is very cool, a lot like us. And I can safely announce this now. April will be joining us on Sidebar tonight as a special guest panelist. So, do check her out with us this evening, 8 p.m. Eastern, 5 p.m. Pacific. Okie dokie. Let's go back to Judge O'Donnell, new contestant.
Thank you, Your Honor. We're here today in the state of Ohio versus Jason Cornell, case number 26-CR874. The defendant is present with counsel Nicole Novotny. We're here today for an information hearing. It's the state's understanding the defendant is going to waive his right to have his case presented to the grand jury and plead guilty to the 1-count information, that 1 count being grand theft of a motor vehicle, a felony of the 4th degree. There's no agreement as to sentencing, and the state would ask for a pre-sentence report. Thank you.
Novotny,
Yes, Your Honor, that is correct. Before coming into court today, Mr. Purnell and I went over the written waiver of indictment as well as the written plea of guilty paperwork. Mr. Purnell displayed an understanding of what those documents entailed and would like to continue to change his plea at this time.
All right, Mr. Parnell, how old are you?
52, sir.
How far did you go through school?
12.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of the information that was filed in this case?
Yes.
Any questions about it?
No, sir.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes, sir.
Your Honor, myself and my client signed the waiver of indictment and passed it to the prosecutor. Witness the same.
Your Honor, I witnessed the defendant sign the written plea of guilty and him sign the same.
All right, I'll accept the waiver of indictment. What's the bond in this case presently?
Presently, $100,000 cash rate, 10%.
All right.
No firearms.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. And I'm going to ask you some questions. If you don't understand a question, let me know. If you want to talk to Ms. Novotny some more, let me know that, and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal that guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
And if you file an appeal, you'd have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Grand theft of a motor vehicle is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
No, sir.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority can send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. You understand that?
Yes, sir.
If that violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Ms. Novotny before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
Ms. Bell, if the case went to trial, what would the evidence show?
Your Honor, had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 4th, 2024, the defendant arrived at the Circle K in Madison Township on a bicycle. He then stole a 2002 Honda Odyssey, which belonged to Deborah Nagel, without her permission. The police responded to the scene, collected DNA from that bicycle. It matched DNA that was found on the Honda Odyssey when that was later found. Thank you.
Thank you. Ms. Novotny, anything to add to those facts?
Nothing, Your Honor.
Mr. Parnell, did you hear what Ms. Bell said the facts would show if the case went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to grand theft of a motor vehicle, a felony of the 4th degree?
Guilty, Your Honor.
Ms. Novotny?
That document, right? Okay. Sign date. Today's date is 8/20/26. Your Honor, in open court, myself and my client signed the written plea of guilty paperwork and passed it to the prosecutor witness the same.
Your Honor, I witnessed the defendant sign the written plea of guilty and then sign the same.
Mr. Parnell, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes. Yes, sir.
I'll accept the written plea of guilty. Defendant was present with Ms. Novotny, advised of all of his rights from a knowing, intelligent, voluntary waiver. He understands the nature of the charge, consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find him guilty of grand theft of a motor vehicle, a felony 4. I'll refer this for a pre-sentence report. Sentencing will be September 30 at 1 p.m. and the bond is revoked. Anything else, Ms. Bell?
A victim impact statement,
And
Your
a
Honor.
victim impact statement. Ms. Novotny, anything else?
No, Your Honor.
All right, we're adjourned.
All right.
Good morning once again, everybody. It's TCF Live on a Thursday. Starting to be a good-looking morning here at the bunker after a night of heavy storms. The sun is trying to come out and grace us with its presence because it has a job to do. We have to be like 197 degrees today because we're in the desert. So, it needs to get to work. Let's do this. Let's head south to the land of snakes, rats, and the Lord. This is Judge Mercer.
Merrill Foxworth. Mr. Foxworth. Foxworth, good morning. Mr. Foxworth, you're here for a holdout of Liberty County. I took a look in the computer system this morning. try to find out, see if there was a bond on the warrant. It's a violation of county probation charge. There's no bond on the warrant. What that means, Mr. Foxworth, is you'll be held for Liberty County. You'll be over there the next couple of working days. When you get there, you'll go to another first appearance in front of a local judge, and that judge will address your bond further. You may or may not get one. Violation of probation is a situation where sometimes you don't get a bond. It may be a no bond case, but the warrant doesn't say either way. You have any questions, Mr. Foxworth?
No, sir.
All right, sir. Wish you the best. Terrence, Mr. Oliver, good morning. Mr. Oliver, you're here for first appearance accused of one count of driving while license suspended or revoked with knowledge. I've read the complaint in your case. There is probable cause for the charge. And Mr. Oliver, I'm going to appoint the public defender's office to represent you for purposes of first appearance. Please listen to Mr. McDaniel, your attorney. Your Honor, we just ask for reasonable bond. Anything else on behalf of Mr. Oliver? Mr. McDaniel, anything? Mr. Mitchell?
We just request he have a condition that he not drive without a valid driver's license.
So, Mr. Oliver, you've got multiple arrests this year, several. This is, I think, your fourth arrest in 2026, but you're still entitled to a bond under Florida law. I want to ask Mr. Mitchell to notify the Alabama authorities if he can. That's kind of difficult when you cross state lines, but make them aware of this arrest. I have no idea if you're out on bond or anything. The reason I'm not going to hold you, sir.
I don't have no warrants on no bonds.
I'm telling you had a warrant, but you have three Alabama charges from this year alone. You may have resolved all of them. I have no idea.
But I'm not. They all got dismissed. Like it was a misunderstanding. They all got dismissed.
You say so. I don't necessarily believe that. It doesn't matter though. You've got 4 arrests this year. Your bond's $5,000 cash or surety. You have a condition not to drive a motor vehicle. If you get a license, you come back to court. We'll talk about it. We'll cross that bridge. But you haven't had a license for a few years, according to the complaint. So I don't, hope you get a driver's license. I hope I'm wrong. Hope you will get one. But your bond's $5,000, sir. You have the right to use the phone in a few minutes to try to post the bond. Cash or surety bond means you can go through a bondsman. You don't have to come up with all of it. And Mr. Oliver, the jail's going to give you a notice for your court date, which should be.
I'm not sure. And
she cut it off yesterday.
September 28th. September 28th.
28th.
Yes, September 28th. September 28th is your court date. The jail will give you that notice for 9 a.m. that day. Do you have any questions, Mr. Oliver?
No.
Have a good day. We have Joshua Jones. Mr. Jones, good morning. You're here for first appearance. You're accused of one count of battery, domestic violence. Mr. Jones, I've read the complaint. There is probable cause. And I've also looked at the criminal history in your case. I think you're entitled to a bond. As far as I can tell, I have to set you a bond, but let me see what the attorneys have to make sure I didn't miss anything. Mr. McDaniel, anything?
Your Honor, I'm trying to go off my recollection on this, but clearly the victim, I don't think is a person who called the police, and she didn't even want to do anything. And I'm not even sure she even alleged a battery. A battery is unlawful, unwanting touching. I don't even know if she even said she didn't want it or anything like that. I thought it was kind of vague, the officers, in his affidavit. And based on that, we just asked the court either to find no probable cause or to find, if they do find probable cause, to basically give him some kind of, he is working, he said, been working for a couple of years at a location. We asked the court to consider, some kind of reasonable bond or cash bond if the court's inclined to, if the probable cause is found.
Thank you, Mr. Mitchell.
Your Honor, I understand there's issues when it comes to the independent witnesses that are in this case. I'll leave it up to the court to determine probable cause, but if he does get a bond, we just request that, since there was an allegation of that he was drinking heavily when it happened, that he not be allowed to possess or consume alcohol.
Thank you. So I'm going to find there is probable cause. It's based upon this statement in the complaint. Ashley agreed to speak to me about what happened. Ashley then began to state they had gotten into an argument because of how drunk Joshua was and the behavior he was displaying. She stated that Joshua has physically put her hands around her neck and throat, but stated he did not squeeze her neck. Ashley then got word about Joshua seeing her and retreated inside the residence. So that's enough for probable cause. The more concerning statement is this. Deputy Clark heard Joshua state that when he got out of jail in the morning, he would return to the residence and kill everyone there. So, Mr. Jones, the officer says that you said that. That's always concerning when a judge reads something like that. Nevertheless, I have to set you a bond because you're entitled to one under Florida law. Your bond is $5,000 cash or surety. You have a condition of no contact with the alleged victim. You have a condition not to go to that property, and you have a condition of no alcohol. Do you have any questions, sir?
Yes, sir. If the alleged victim said that I did not do anything, my sister, she's in trouble with y'all all the time
Mr.
for
Jones,
abusing people.
Ms. Jones,
how is
Ms.
that
Jones,
affecting me?
Mr. Jones, this is John McDaniel. I talked to you before. The bond's 5,000. Nothing you say is going to change that. The only thing you're doing is hurting yourself, okay?
Yes, sir.
Mr. Jones, the alleged victim has not said you didn't do anything. She said quite the opposite. I just read to you what she said. So your bond is $5,000 cash or surety. The jail will give you a notice for your court date. It'll be September the 28th.
Yes.
At 9 a.m. You will get to use the phone for first appearance purposes to try to post bond in just a few minutes. You cannot go back to that property and you can have no contact with the alleged victim. If you do, and I find out about it, there's going to be a no bond warrant issued and you're going to be in jail with no bond. Stay away from her, let the situation calm down, and we'll see what happens when you come to court. Do you have any questions?
No, sir.
All right, so you can step away.
Yeah, they did.
Well, we have a little bit of dead air. Barbara gifted 5 memberships earlier, and I had yet to acknowledge that. So thank you, Barbara. I very much appreciate that. Looks like maybe we're coming back. Here we go.
A friend, yeah, it's been 8:30 for 30 years, ma'am. Sorry for giving bad information from your friend. So, Corporal, we lost you for a minute, but we're back connected. Is Mr. Jones still in the room out there?
No, he stepped, I took him out to the phone. I thought we were done.
Okay, so will you let him know that he had friends or family come up? And I want to tell him who showed up for him, ladies. What's your relationship to him? Mom and a girlfriend?
Okay.
Are you the alleged victim? Are you the one that told law enforcement he put his hands around your throat?
Are you the person from last night, yesterday? You're acting.
Yeah, it's okay. So what I did is I set him a bond of $5,000 cash or surety. He has a condition of no contact with you. That means no contact at all, period. And he also has a condition he can't go to that property. And if you'll let him know that his mom and the alleged victim both showed up in court, Corporal, after
Yes, sir,
his
I sure
first
will.
appearances. Thank you, sir.
Yes, sir. Thank you.
You ladies have any questions?
Well, I needed a lot to say.
Ma'am, I can't help it. We started the time. You got here 10 minutes after it's over. First appearance is over, ma'am. I'm sorry. Somebody told you the wrong time. You probably should have called the courthouse instead of relying on your friends for the time.
Out there, I will have our victim advocate come and speak to you. You can give a statement to her and that'll be put into our system, okay?
Thank y'all for coming. All right, so I think that's it from the jail. Mr. Mitchell, anything else for first appearance purposes?
No, Your Honor.
Mr. McDaniel?
No, Your Honor.
About to creep up on hour 2 of TCF Live here on a Thursday. Thank you all so much for being here. I appreciate it. We have a full slate of programming today. We have this show, and then at 2:30 Eastern, 11:30 Pacific, we have second session, and then tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific. So there's no need to go anywhere. Just hang with us all day. Alrighty, let's go back to Michigan. Check back in with Judge McNally.
Your name?
Well, I was
What's your name?
Logan Scott Davis.
Wait a minute, slow down. Don't tell me you're coming in here and asking for time to pay. You're not doing that when the case is 13 months old. What in the world? It doesn't say the bank of the 33rd District Court out there, does it?
No.
Where do you work?
I work at Aaron Battles Painting.
Why aren't you paying this? What's going on? Heather, what was the due date on this?
Let me take a look. It looks like this one was connected with a probation case. This is a civil infraction with a probation. We had this one due by June 1st.
Of this year?
Yes. He paid the probation case is paid off. And then this was supposed to be paid, it looks like, after he was done with the probation case.
Done with probation?
No, but I will be shortly.
Talked to me about this earlier. Just feel like I don't get it. You know what I mean? I don't understand this.
I apologize, Your Honor. I thought I'd paid everything off.
All right.
Last time.
How much can you pay them?
I can pay at least 100.
How much do you make per week?
About 500-600, just depends on how many hours I get.
Pay 100 now, 40 per week, beginning September the 18th. If you don't have the money, you come and talk to me on or before the due date. I'll be more than happy to give you an extension. I just can't stand it when people ignore me. Good luck. 100 now, 40 a week. Albert Lopez, 26B151236 A, B, and C. Your name? Good morning to you. You're at your charge of driving on a suspended, no insurance, and speeding. You have the right to an attorney. Would you like one? Okay, I'm going to give you a lawyer. Somebody showed up on time, John.
Right.
Go out in the hallway and we'll get you a lawyer, okay? He'll set you up. And either way, you're coming back in front of him. Good luck. Haynes Enterprise. Haynes Enterprise, 26B151345 A and B and C. Nah, this isn't going to work out, sir. Come on. Your name? I cannot. Are you the owner?
Yes, sir.
Is it Haynes?
Yes, sir.
And you are the president and owner?
Yes, sir.
I can't let you represent the company. It's not my rule. I don't make rules. I just know what they are and I abide by them. You have to hire a lawyer. Again, it's not my rule. So I'm going to have you hire a lawyer. I don't make the rules. So.
Are any of these payable now, or?
I wouldn't pay any of them because you got the misdemeanor, and that's the one that you need the lawyer on. I can't let you represent the company. It's a separate entity. You're engaging in the unauthorized practice of law. That's just the way it is. I don't know what to tell you. I'm not trying to get lawyers' business. Sure. Give me an arraignment pretrial date, Lisa, please. Another one. Heather.
We can do, excuse me, September 3rd, or I'm sorry, this one, I forgot we have Brownstown in. This is a Brownstown case. So we can do September 9th at 9:15.
15. Okay? So you go down the hall, we'll give you your notice. I really am sorry about this. Okay. Have a good day.
Thank you.
What is Mr. Shemke here on? I don't want to, if he's in front of Judge Hess.
Here for the
He's our arraignment
plus
attorney.
use on Zoom right now.
All right, we can take that one. Lisum Harp Shahada, 26F245828 and 26W842430. Come on, are you Mr. Shahada?
Yeah, I am.
Come on up to the podium there, sir. Your name?
Sam Shadden?
You owe 237 on the 828 file, 213 on the 42430 file. They're separate offense dates. One is February 28th, the other is April 13th. Why didn't you pay those?
No, I couldn't pay at the time.
How much do you have today? You have it all?
You got to put them out.
You got the full amount?
Yeah.
Next time come to court though, okay?
Okay.
I'm sorry?
I'm trying.
I'll tell you what, you pay on the impeding $200 balance waived. You pay on the speeding, I'll make that $180 for you, balance waived. So you have $380, right?
Yeah.
That's what I'll do for you. At least you showed up today, but you gotta show up in the future when you get your court dates, okay? Good luck. Springhoff, Natalie Marie Springhoff, 26I-415-301. All right, so I said it informal on this officer, your name
Nathan
White.
and your name, ma'am?
Natalie Marie Springhoff.
You're charged with stop sign violation. Where do you live now?
I live on 11501 Petoskey Avenue, apartment 319, for the shoes.
Do you want to offer impeding officer? I think you were offered that before, but didn't want it, right?
That is correct.
You want to plead to impeding, if I can get it for you?
What is that?
Means 0 points. It won't go on your record.
No, because,
See, he says I, ran past the stop sign.
Okay, so listen, here's the deal. If you don't want to do this, you don't have to. I'm just trying to save you some aggravation. If you lose this 3 points is assessed.
And
If you plead to impeding, there's 0 points. It won't go on your record. We're not sending it to the Secretary of State. So I don't care if you fight the ticket or not. I just want to make sure you understand that.
no, I understand.
You still wish to proceed with the hearing? Are you sure?
Positive.
Okay, officer, raise your right hand. Ma'am, raise your right hand. Your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Officer?
I do.
Ms. Springhall?
I do.
Okay, go ahead, officer.
On the date and time of July 29, 2026, I was responding to a 911 medical emergency at the Airport Inn at Meridian and Grow. I arrived on scene and the fire department and ambulance was already on scene and I was getting ready to cross the street. I had parked opposite of the location when I observed Miss Springhoff in her vehicle disregard stop sign at Meridian and Grow, which is a major intersection for us. I deemed that it was more necessary of me to address Miss Springhoff, considering that the ambulance and fire department was already on scene to handle the medical
Which
emergency.
direction was she going at the time she disregarded the stop sign?
She was traveling westbound on
So
Grow.
she was westbound on Grow, and was she going straight through Meridian?
Correct, straight through.
So no question in your mind, but that she ran the stop sign?
No question in my mind. My vehicle was parked parallel to the stop sign, and I reviewed my dash cam footage because I wasn't able to capture the infraction on my body worn camera. She's traveling at a normal rate of speed, which is 35 on Grow, and approaching my vehicle, it would be impossible for her to stop in time completely before the stop sign.
And you saw her run the stop sign without even braking?
Correct, Your Honor.
You have any questions of him?
No, I believe that is not correct because my vehicle comes to a shut off every time I stop. Now I had
He said you didn't stop.
I did because I had already noticed him and he was getting out of his car and walking around the car. So my car is going this way.
Wait a minute, slow down.
His
You're going westbound, right?
all right.
You're on the Grow, right?
Yeah.
And you were traveling through toward West River Road, correct?
I'm not too familiar with the area, but yes.
Where were you going?
I was going back to the Woodhaven warm-up.
Okay, so you said you were parallel with Grow, correct? Officer, is that true or not?
Correct, Your Honor.
What side of the street were you on?
I was on the south side of the street, parallel with the stop sign.
Okay. And were you pointing westbound?
I was facing eastbound.
Okay, how far were you from the stop sign?
I would say approximately 5 to 10 feet from the stop sign.
Okay. And you checked your dash cam?
Yes, Your Honor.
Did that reflect that she had gone through the stop sign?
It does not capture the actual infraction of her disregarding the stop sign. Just based on her speed that she's approaching the stop sign, I feel that it would have been impossible for her to stop in time.
Let me just ask you this. You still want me to make a decision, or do you still want, and I will let you do this at this point, if you want. I'm not done. Are you still willing to offer impeding?
Yes, Your Honor.
You want me to make a decision, or you want to take the impeding? You got a pretty good record here.
No, I don't want to take the impeding.
Okay.
Because I don't feel like everything he just stated was exactly how it happened, because he wasn't 5 to 10 feet from the stop sign. He was well over 100 feet away from the stop sign.
So over 30 yards? That's quite a way. That's further than the.
His car was in the opposite direction from where I'm at. Now, I made a complete stop. The car shut off, and he was still walking around his car, and his car.
You still have the dash cam video?
Your Honor, I'd be able to obtain it when I get back to work.
When are you going back to work?
I return back to work on Monday. I'm on vacation right now.
You want me? I'll do one of two things. I'll do one of three things. You can either still take the impeding. I can make a decision now, or we'll adjourn this. I'll let you appear by Zoom if you know how to get on Zoom. I'll let you appear by Zoom next week, and we'll look at the dash cam together. Can't be more fair than that. What's that?
The third one is better.
Okay, we're gonna adjourn this. You can give me any date next week, Heather. I'm not worried about having a docket we can do it at 8:30 what day? Are you working days, officer?
Yes, Your Honor.
Good. All right, why don't we do it at 8:30 in the morning one day next week? Is that good for you?
Any day.
We could do Thursday, August 27th.
August 27th at 8:30 in the morning, okay? And I'll just make a note. Defendant may appear by Zoom. You sure you know how to use Zoom?
Yes.
I want to see the dash cam. And we'll put it up on the screen so you can talk to the staff about getting that all ready if you would. Heather, you know how to take care of that, right?
Yes.
Yeah. So that's what we'll do. Okay? Good luck. Jonathan Glenn Compton, 25W39357. Pull out Mr. Shemke's. John, please.
He's on Zoom, Judge.
Which case is that, counsel? Where's Compton at?
He's on Zoom.
Jonathan Glenn Compton, 25W39357. Mr. Compton, you got to start your video and state your name. Mr. Compton, you have to start your video and state your name, sir. Are you Mr. Compton? That's not Mr. Compton. Well, whatever. What case, Mr. Shemke?
Jeremy Shaw is in custody with Woodhaven PD.
Jeremy Shaw. Jeremy Dwayne Shaw. 24W8344431.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Your name, sir?
Jeremy Dwayne Shaw.
So I sentenced him to pay restitution in the amount of $960. This was a fraudulent scheme case back from October 1 of 25. That was the sentencing date, it appears. Is that right, Heather?
I'm sorry, what was the date you gave, Judge?
October 1 of 25.
Correct.
And then Mr. Shaw failed to appear for sentence.
No, I was there. The Zoom, I was in custody, Your Honor.
I'm talking to your lawyer, right?
Your Honor, my client said that he was in custody for approximately 6 months, and then actually he had additional time, and he just got out on July 30th.
Well, if he was in custody for 6 months and got out July 30th, he wasn't in custody on October 1 of 25.
It's two separate times.
Two separate times,
Shaw,
correct.
listen
Yes.
to me.
I'm
I
sorry,
got a
Your
lot of people and I got a big doc.
Okay, I'm sorry, Your Honor.
You're not gonna just start interjecting here, got it?
Yes, Your Honor. I understand.
So that's what I'm trying to tell you nicely. If he was in custody for 6 months and got out July 30, that means he got in at the end of January or beginning of February, which is 4 months after October 1 of 25. Why wasn't he here?
Correct, Judge. He had 2 times that he was in custody. He had a 6-month stint and a 4-month stint that he was in custody. And he maintains that he was in custody.
I'm supposed to take him at his word.
Judge, we do have notes in the system saying per Monroe County defendant has been released and then defendant now in custody at Wayne County Jail. And it looks like we sent a writ, but I'm assuming he was never produced. It looks like.
Is he in custody on October 1 of 25?
That's according to our notes. That's all we have. It looks like according to our notes, he possibly would have been, but I'm not sure how we would look back to find that out.
Done better on this sentencing, Mr. Shaw. I could not have done better on this sentencing for you. I didn't order anything. I ordered restitution of $960. I didn't even order the 75 victims' rights or $50 justice assessment.
Thank you.
Well, thank you.
I didn't know that. I didn't hear the sentencing. I wasn't there. I didn't know that. I just start working.
Wait a minute. That's what I guess I was going to order. I'm a little confused on this. What happened here? Why is he in front of me? I don't have all I have is I see we had a PSI. He didn't show up for that. And then we rescheduled it because he was still in custody on September 17th. I made a note he was still in custody at the Wayne County Jail. New writ to jail, bench warrant to issue when he didn't show up for sentencing. I see what happened now. My apologies. When was he taken into custody?
He maintains that actually there was a time where he was in court in custody and he was disconnected from the Zoom and they were unable to reconnect. That's when he maintains that he
was citizen.
Tried to take every effort to correlate with court's order, but was unsuccessful doing
Not
so.
order restitution. I must have just written that down. I didn't sentence him on October 1 in absentia. I wouldn't do that. That wasn't it. I just wrote down restitution was going to be for $960. All right, here's what I need to do. I need to set a bond and I need a pre-sentence report. We're going to do that, have probation do that, Heather, today. PSI, sentence date. I don't know why he didn't show up when he wasn't in custody. Does he work?
Your Honor, yes, he actually just he got out on July 30th. He lives with his aunt in Wyandotte, and he just got a job recently at Burger King in Lincoln Park. He has not yet got paid on that.
3,010% is your bond. Give him the earliest date you can give him next week. Do a PSI. Remember, probation has to generate that. So give me a date for next week. It doesn't.
I'm gonna lose my job, Your Honor. I can't pay
You
a
should have
bond right now.
thought
I got
about
no
that
money.
before you ignored the court, sir.
I didn't know him. I was literally dropped. We was going for sentencing already. PSI was already done. I was going for sentencing. Then the court Zoom got dropped.
Listen.
I don't have $300, Your Honor.
Well, I'm sorry about that.
I just started working.
Sure, yes, you have.
I'm not going to argue with you, sir.
I'm not arguing with you either, sir, but I'm saying it wasn't my fault. I didn't miss that.
I'm sorry. Listen, stop interrupting me. That's what I'm doing. 3,010%. We're doing
I don't
a
have that,
PSI.
Your Honor. I don't have
Mr.
that.
Shaw, then I'm going to set 100,000.
It don't matter, but it could be 100, it could be a million. It
You're
doesn't
not
matter.
going to argue with me.
I don't have the money, Your Honor.
Okay. Too
I'm
bad.
going to jail. I just got out of jail. I'm going back to jail.
Too bad.
Oh, yeah, too bad, man.
Give me a date, Heather.
I'm withdrawing my plea too.
Knock it off.
I'm withdrawing
Turn
my
around
plea.
here
Use
right
it.
now, or I'm
I'm
going to have you
withdrawing my
brought
plea.
over right now.
Man, you ain't talking about nothing, man.
Did you hear what I said to
No,
you?
I didn't hear what you said. It's because it's bullshit. I was at that hearing. I
don't
and it got
care.
dropped on me, man.
All right. 10% will be the bond.
That's fine.
And if you say another word, I'm setting the sentencing for next December. You got it? That's all I need is one more word out of you, tough guy.
Not being tough, Your Honor.
Give me a date for next week, Heather.
We're pretty open to any day, Judge, as long as they get the PSI done.
Yeah, so we could do Tuesday. We can do Tuesday. Okay, let's do it Tuesday, actually, this is
25th.
Woodhaven though, and it is a restitution case. I should do
there
it
is
on Woodhaven Day.
That unfortunately we do not have Woodhaven because Judge Hessen's off next week and it's her Woodhaven day. We
Then
don't have
let's do it
Woodhaven.
on Tuesday.
Okay.
That's the 25th at 8:30 in the morning. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. This was a fraudulent scheme case. You'll be lucky if I don't send you to jail. That's it. Good luck. Better be more respectful next time, young man. I'll say that with all respect. Good
Yes, Your
luck.
Honor.
Thank
Sorry.
you.
I'm just
Rebecca Ann Montez, 26F246402.
Good morning, Judge. Peter Bernard, P78413, MIDC counsel for Ms. Montez. Ms. Montez, can you state?
Rebecca Montez.
All right, so this says proof issues and no new charges. So they're going to go ahead and dismiss the case. Case is dismissed. You are all set. Good luck to you. Thank you. Rasmussen? Michael, is that yours, Mr. Granado?
No.
Which one do you have, Mr. Clovis?
Not till 10:15.
All right, Michael, James Rasmussen, come on up here. 26B151223A and B and C and 26B151229. Your name?
Michael Rasmussen.
All right, you're charged with possession of a controlled substance. You have a defective equipment, possession of drug paraphernalia, and drive while suspended, and you have the right to a lawyer. Would you like one? You don't want a lawyer?
I don't know if we can put this behind me or.
Well, you should get a lawyer.
All right.
You don't have to have a lawyer. You can represent yourself if you want, but I would strongly suggest you have a lawyer.
All right, better that I have one.
You didn't go to law school, right?
I go to law school, sir.
All right. Well, these are kind of, I don't know what the drugs are. I don't know anything. I'll give you a lawyer, okay?
Okay.
Thank you.
What are
You can go out in the hallway and he's going to set you up with a defense lawyer. Then either way, you're coming back in front of him, okay?
Thank you.
Do I have Madison Guess here?
She's on Zoom hearing.
Madison Renee Guess, 26F246621.
I'm here, Your Honor.
MIDC counsel for Ms. Guest. Ms. Guest, could you state your name for the record?
Addison Guest.
Am I letting these people show up by Zoom?
Judge, you did give her permission to appear by Zoom.
Why?
She's breastfeeding. It was.
Okay, fair enough. Let me just check one thing. Probation did not notify the victim on this case. That's what they wrote. But all the items were retrieved, so it's okay. I took the plea to disorderly under 771.1. They don't typically show up on any of those. This was and they don't typically show up on any of these. So I'm going to go ahead and I'm going to sentence her. I did not order a pre-sentence report. And I'll ask you, counsel, if you have anything you would like to say on your client's behalf.
Thank you, Judge. If I may, Ms. Guest is 30 years old. She has 2 children. One is 3 months old. She also has a 2-year-old. She's a stay-at-home mom. She is receiving Medicaid. She's got her high school diploma from Allen Park. And we'd like the court to consider that prior to sentencing.
Are you married, ma'am?
No, sir.
How are you supporting yourself?
Basically my family. I lost my job at Ford Motor Company when I was pregnant due to being pregnant. And I'm currently in a lawsuit suing Ford Motor Company for wrongful termination.
You didn't really need the camping chairs, did you? You didn't
No,
need
sir.
a Toy-Story Lego set, right?
So
you don't play
that was
Legos,
paid
do you?
for.
You don't play Legos, do you? Play Legos? You play Legos?
No, I don't, sir.
Who plays Legos?
No, sir. My son.
How old is your son?
2.
And you have another child? Okay, I got it.
Your Honor, I would ask the court if, instead of a court work program, because of the fact that she's breastfeeding, that you allow her to do community service instead. If that's
Anything else that anybody wants to say? Ma'am, anything?
I'm very remorseful. I made a mistake, and it's not a mistake that I'm going to make again. There's no excuse for it. I did have a very rough day. I'm struggling with postpartum. If you could give me a little bit of leniency, you will never see me again.
You never got printed on this, right?
No.
You have to go get printed, okay? 6 months probation. I'll take this under section 771.1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You are to appear at the Flat Rock Police Department by tomorrow, August the 21st, to get printed. That is an order. Do you understand that?
Yes, Your Honor.
That's by noon tomorrow. I'm filling out an order. We're sending that to them, so you have to go there by noon tomorrow. I'll give you that extra day, all right?
Your Honor, could I ask you a question?
Yeah.
Do you think that 6 months is a bit much for this? This is my first offense. I'm not in trouble for anything.
You can appeal if you want. That's what I'm setting. I believe that's what you guys agreed to. I wrote down.
No, there was no probation.
Ma'am.
Sorry. I was just very unaware of the probation.
You thought it was just going to be a simple, sorry, we brought you in here?
No, sir.
Prosecutor wrote down 6 months. Prosecutor wrote down 6 months. You guys agreed to it. Disorderly conduct, they pled it down to, from retail fraud. I'm not revisiting that. I would have covered that with you ad infinitum at the time of the plea. So that's what I'm ordering. 6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must report to probation as directed. I'll take it under section 771.1. You're to appear at the Flat Rock Police Department no later than tomorrow by noon. No later than tomorrow by noon. You're to serve 8 hours of community service by October the 1st, and you are not to enter 27319 Telegraph in Flat Rock or any other Aldi's. So I'm writing down, you have to appear there at the Flat Rock Police Department by noon tomorrow. If not, you'll be show caused and a warrant will be issued for your arrest. Pay fines $50, costs $50, $75 victims' rights fee, $50 justice assessment. That's 2 1/4. Probation fees are $120 for 345. I will not charge attorney fees. 345 is your total. 8 hours community service. Stay out of Aldi's, get printed by tomorrow, or serve 90 days and do your 8 hours community service. I'm going to give you a review hearing date, and that will be in 6 months. And if you are compliant, the case will be dismissed on motion of the prosecutor. But you do have to comply with every aspect of probation. You understand that, correct?
Yes, Your Honor. I was just very unaware of probation. I didn't agree to it. It wasn't discussed, nothing.
I would have gone through that with you, ma'am.
Nobody ever said anything to me about it at all.
Ma'am, if you think you're going to be able to go in and feed people and not be placed on probation, you're coming to the wrong place. I don't know what to tell you. This is what the agreement was. They gave you disorderly conduct with the retail fraud to be dismissed. If you thought I was simply going to say, sorry, we inconvenienced you, that's just telling me that you really are not taking this seriously at all. So I don't know what to tell you.
Sir, that's... I was just never informed of any kind of probation. I was told that I was just going to have to pay fines and fees. I was not ever informed.
That is not accurate, Your Honor.
You don't need to say that. I know it's not accurate. I know it's not accurate. I know you would cover that with her. I don't know what to tell you except, I can't tell whose signature that is on the front, but she signed the back. She signed the advice of rights. She indicated she understood her rights. She got a break from retail fraud down to disorderly conduct, which I'm not a big fan of, but I don't get in the way of what prosecutors do. So I don't know what to tell you. I'm sorry you're disappointed. Next time you don't steal anything, you won't have to be on probation at all. You know what I'm saying? So how much of this money do you have to pay?
I don't have anything currently.
How are you going to pay this? You better get your family to help you out.
I can. Could you maybe give me like 2 weeks?
Yeah, I'll give you 2 weeks. You sure you can have it paid in full by then?
Could I possibly be put on a payment plan?
Yeah, tell me how much.
Could I do $40 a month?
That's not going to get you through probation, and you're going to be on probation for 9 months. If you want to pay $40 a month, you have to pay $340 by the end of probation. 9 times 40 is 360. So you'd be on probation longer than 6 months. You want to be on probation longer than 6 months? I mean, I can change it to 9
No,
if you
sir.
want. Okay.
No,
I didn't
sir.
think so.
How much should I pay?
You pay $60 per month,
Okay.
beginning on September 1. All money due. All money has to be paid, so you're going to have to figure out a way to pay more by February the 1st. The review hearing will be after that, Heather. So we'll give her a review hearing date. You give me that date if you would.
That'll be February 18th.
So you can stay with that plan, but you have to pay all of your money by February 1 because I'm setting this for a review hearing on February the 1. I'm sorry, February the 21, you said?
February the 18th.
Oh, I'm sorry, February the 18th at 8:30. You wait there, probation will come on there and instruct you. They'll go in a break room with you. Do you have any questions?
No, Your Honor.
If you have any money, I'm sorry, if you have any problems paying the money, you call the court, we'll go on Zoom, I'll give you an extension, but just keep in mind, you have to have all your money paid by then. You're gonna have to figure out where you're gonna do your community service. That can be at any nonprofit organization, okay? Best of luck. Probation will be with you shortly.
Alrighty, friends. Halfway through TCF Live on this beautiful Thursday. A lot going on in court this morning. It's spicy out there. Speaking of spicy, we'll come back to Judge McNally at some point, but let's go back to Judge O'Donnell, new contestant.
Thank you, Your Honor. I'm here today in State of Ohio versus Lindsy M. Krause, case number 26CR000162. Defendant is present in open court today with her counsel, John Salem. Your Honor, here today for sentencing. The defendant was last before Your Honor on May 26th of 2026, where she pled guilty to count 1, tampering with records, a felony to the 5th degree, and count 3, theft, a felony to the 5th degree, with the agreement to pay full restitution. At that time, a pre-sentence report and victim impact statement were ordered. At a later date, a psychological evaluation was ordered. It's the state's understanding that all of those have been completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Mr. Salem.
That is correct, Your Honor.
Go ahead.
With regard to sentencing, Your Honor, my client and I did submit a sentencing memorandum back in July when we were first here. Since then, my client has begun individual treatment and therapy with Mindfully Mental Health. I submitted that as an addendum to the court. Yesterday, there should be a letter in your file regarding her treatment there. I would present to the court, Your Honor, that my client is amenable to community control in this matter. She is asking for a community control sanction and requesting no period of incarceration for the reasons that I'm about to state. I know that she has a letter that she wants to read to the court. My client has owned up to the offenses in this matter. She's accepted accountability for what she did. She's a single mother of young children who rely on her for financial and emotional support. She has a very strong support system. We've attached several letters of recommendation and reference to her sentencing memorandum, which is before the court. Her brother, who wrote one of those letters, is here today to support her. There's an agreed amount of restitution in this matter. My client is able to put a big chunk toward that immediately following today's hearing, and has committed to me, and which has been relayed to the court, that she would be able to pay at least $300 a month after that. She's gainfully employed, wants to keep her employment. Any period of incarceration would obviously cause her to lose her employment and that they have to start back from ground zero. This is definitely a serious offense, but not the most serious version of violation of this statute, Your Honor. However, she acknowledges what she did, and
I'm quite frankly, I'm not even sure what that means. That's gobbledygook language in the statute. It's pretty serious to Mr. Griffin. It's the most serious to Mr. Griffin.
Absolutely.
So,
absolutely, understood. For those reasons, Your Honor, we're asking that she be able to continue. She started her mental health treatment online on May 8th of 2026 and has since transitioned into in-person. In her IOP, she's expected to go and has been going every single week. I think you go on Wednesdays, if I'm not mistaken.
Wednesdays.
And she's asking the court to give her the ability to continue that and to be able to prove to the court that she can make this right and finally get the mental health help that she needs. She has some diagnoses that are being addressed, and that is what we are seeking.
all right, thank you.
Thank
Ms.
you.
Kraus, what do you want to tell me before I impose sentence?
Oh, stand up. Sorry. Your Honor, I want to start by apologizing to the victims, to my family, and to the court. I'm deeply ashamed of my actions, and I take full responsibility for everything that I did. I know I've caused a great deal of embarrassment and pain for everybody involved in this situation, and there's no excuse for my behavior. I want to be a better person and a better parent for my children. That is why I'm fully committed to making this right. I have agreed to the restitution plan, and I will pay back every penny that I owe. Over the last few months, I have faced my mental health head on through regular therapy. I have recently been diagnosed with PTSD and dissociative amnesia. While these diagnoses do not excuse my behavior, they have helped me understand what I need to address and have allowed me to receive the appropriate treatment. I am committed to continuing therapy and have ongoing appointments every Wednesday in person at the court's request through the end of the year instead of going online. After the end of the year, I will schedule the following year as well, and for going to the unseen for future. I will continue doing the work necessary to stay healthy, remain sober, and live a law-abiding citizen for the sake of my family and community. I also respectfully ask the court to consider my children when determining my sentence. They depend on me both financially and emotionally, and I'm the only parent who provides their daily care. It is my sincere hope that the court will show leniency so I can remain in my home, continue caring for my children, and keep moving forward with my treatment, recovery, and responsibilities as their parent. I understand that rebuilding trust will take time, and I know that my actions have consequences. I am committed to proving through my actions, not just my words, that I can be responsible, honest, and a productive member of my community. Thank you for your time and consideration, Your Honor.
What exactly did you do here with regard to these thefts? Explain to me exactly what you did.
I took money that didn't belong to me and put it in my account.
How did you do that?
I moved it from a checking account that belonged to John Griffin and put it in my checking account.
And how many times did you do that?
3.
And what amounts did you do that?
I believe $2,500, $1,500, and maybe 2,000. I'm not 100% sure. It was like a year ago or more.
How many loans did Mr. Griffin make to you?
A lot. From the time that I started working there, a lot.
Okay.
It was on a constant
And
basis.
how is it that you arrived at an amount and a payback method for each of those loans?
They would come out of my paycheck every 15th and last of the month.
Okay. And the three amounts that you took that you described earlier, were those in the nature of a loan?
No.
Why did you tell, when you were interviewed by the probation department, why did you tell Ms. Knaus that after you were terminated, Mr. Griffin went over the books and found 3 loans that he said he did not know about, and that you said he knew about all these loans she took, but takes responsibility because you should have, in your words, covered your butt? Why did you portray those as loans that Mr. Griffin should have known about but didn't know about?
What do you mean, what should have known about but didn't know
Well,
about?
you indicate that after you were fired, he went over the books and found 3 loans he said he did not know about. And you said, meaning the 3 transactions that you just talked about.
Okay.
That he should have known about them, and you should have covered your butt by documenting it. So you perceive those to have been loans. You portray those to Ms. Knaus as having been loans. Why did you do that? They weren't loans, right?
No, they were not.
Right? But you insisted to her, Ms. Knaus, that they were loans that Mr. Griffin should have known about but didn't know about.
No.
Okay. Well, you did. That's what you said. Okay.
I mean, I did actively put them in Sage, but I did not actively ask John.
Okay. And well, isn't the nature of a loan that you come to some agreement with whoever's loaning the money?
Correct.
About the terms, the amount, and the term?
Yes.
Okay, so it looks to me like you're trying to soft sell what you did as some misunderstanding.
It's not.
Well, I know it's not.
Right.
Everybody knows it's not, except you seem to still hold on to this rope that it was just some big mistake that was made that shouldn't have been made.
No, I clearly understand that it's not. I had myself in such a deep hole, like such a deep hole. I had so many loans. Like from the time that I started working at Griffin Technology, I had so many loans. Like from day one, my first paycheck was a loan. My very first paycheck was a loan because I wasn't going to get paid for like 4 weeks. So John was kind enough. He said, okay, well, I'll give you a loan for your first paycheck, which obviously got paid back.
So what you did?
So I was always in the hole. I was always in the hole. Okay. I was constantly in the hole.
All right, so what you did.
From day one.
What you did.
I got myself in the hole. I'm sorry.
What you did was take complete advantage of Mr. Griffin's good nature, right? That's exactly what you did.
Yes, at the end. Yes, you're correct.
Now, why were you terminated?
They say because I messed up invoices and I had a bad attitude, but there's a paper that says exactly why, but that's exactly why I was terminated, yes.
Well, I don't want to know about the paper that says why. I want to know why, in your mind, why were you terminated?
Messing up invoices and making mistakes over and over, I guess.
Okay.
Nothing pertaining to this.
Because you didn't know about it until they went over the books after you were terminated, right?
Correct.
So how long after you were terminated did you find out that he found out about these thefts?
Not until I was pulled over and arrested, which
When was
in
that?
February.
In February of 26.
Yes.
Right.
On the 18th, to be exact.
In your mind, would that have been a good reason to fire you if they knew about it
Sure.
before they fired you?
Absolutely.
Why did you filed an EEOC claim against Mr. Griffin's
I did,
company?
yes.
Okay. And when did you file that?
I filed it in October because I had asked for time off because of my mental well-being it was declining.
Okay.
There was a lot of other stressors at work as well.
And you were denied that, right?
I was denied it after this case was brought up. Yes.
No, denied the time off.
Oh, denied the time off?
Right.
I was terminated the next day.
Okay.
That's why.
And then you filed this EEOC claim when?
Like a week later?
And that continued on through actually yesterday, right?
No.
No, there's a release dated August 19th.
I have not been messing with that at all, Your
Okay.
Honor.
Well,
I've been ignoring them.
okay.
I'm not talking to anybody. I'm not
Who's
involved with
Cahill?
them. Who?
Who's Cahill?
Your Honor, Robert Cahill's the attorney for Mr. Griffin and his company.
Oh.
You might not have known.
Oh.
He drafted the release.
All right, so after you were pulled over on February 18th
Mm-hmm.
and were arrested, were you arrested then?
Yes.
So you knew about the theft then. You knew that they knew about the theft then, right?
Yeah, that's when I found out. Yes.
And this EEOC action continued after that
Mm-hmm.
point in time, right?
Yes.
For quite a while,
Yes. Until
many months.
Yes, until you asked me to.
Listen, I got nothing to do with this. I found it.
Oh.
I found it when you were here on the plea on May 26th. And I was told of this EEOC claim. I was a bit outraged. Quite a bit outraged.
Okay, that's fair.
It's fair. Well, it's either fair or not fair. That doesn't really matter, okay? But that was May 26th. After that period of time, there's quite a bit of activity from the defense of that claim by Mr. Griffin's company with Mr. Cahill, which involved a lot of money. So you get away with 11,000 some odd dollars. He pays about another 15,000 to fight this bogus EEOC claim, which doesn't go away until yesterday, which continued to be active because Mr. Cahill was active on behalf of Mr. Griffin through sometime in July. So what's the appropriate penalty for something like this? What do you think is the appropriate penalty for something like this?
I'm not sure. I have no idea.
The solution as you indicate, and as Mr. Salem has represented, is to pay back a chunk of, I don't know, 3,500, I think was the number, and then pay back the remaining 8,000 over time. And the request is that there be no incarceration penalty because you have to pay it back, and because of your kids and the care of your kids and all that stuff, right?
Yes.
Okay. Now, I don't know, 12 years ago, 10 years ago, 11, 12 years ago, you had this identity fraud in Geauga County,
Yes.
in which you took advantage of your older two children's grandmother on their father's side by putting a credit card in her name and you taking the proceeds, right?
I did use it, yes. Yes,
Kind of similar to here.
yes.
So when you go to this mindfully, I've never heard of mindfully, but what do you do there? You've been there 4 times. What do you do?
We're going to be working on.
What have you done so far? What have you worked on? Tell me, explain to me what happened.
We're working on my childhood traumas, my teenage traumas, working on how to not disassociate from things that have happened because I have dissociative amnesia. And then there's things called EDMR and CBT therapy. So those will be different therapies that I work on. But it's a process, so you have to start from the beginning and then work your way up to those type of therapies.
Okay.
And then EMDR is another therapy that I'll be working on. But that's not listed in the paperwork.
You had gone to Signature back 12, 14 years ago.
Yeah.
How long were you there?
When was I there?
How long did you go there?
Maybe 2 or 3 years, possibly.
What was your diagnosis there?
Depression, anxiety, bipolar, I believe.
What's your drug use been?
Nothing as of right now, but before just marijuana.
On a daily basis, right?
Mm-hmm. Correct.
Where are you working now?
Handlebar.
Where's that?
It's in Bedford.
Doing what?
Bartending.
Where do you live right now?
I live in Chesterland.
And who do you live with?
I live with Gail and my 3 children.
Gail from the credit card case?
Yes, I do.
All right, what else you want to tell me?
I mean, I'm gonna continue doing everything I'm supposed to be. I have been doing everything I'm supposed to be doing. I'm not really sure.
All right, have a seat. Ms. Cutts.
Thank you, Your Honor. Your Honor, Mr. Griffin is here, as well as other individuals related to this case who would like to address the court.
Good morning, Your Honor. My name is John Griffin, and I'm representing my company's Griffin Technology Group and Vector Aviation. Between the dates of May 22nd, 2025 and October 2nd, 2025, we were the victims of criminal offenses committed by Lindsy Krause. This year marks the 25th anniversary of Griffin Technology Group, an information technology services company that provides technology support, cybersecurity, and business solutions to organizations throughout Northeast Ohio and across the country. I started this company with a goal of supporting my family, creating opportunities for others, and serving our community. Over the years, I expanded those goals through other business ventures, including Vector Aviation, a flight school and aviation training company that helps individuals pursue aviation careers while serving the needs of our local community, with the same commitment to creating opportunities, supporting employees, and building businesses that people could depend upon. For me, this case is not simply about the money that was stolen. It is about trust that was violated, blatant dishonesty, and a complete and continuing lack of accountability for Ms. Krause's actions. Ms. Krause was not a stranger. She was an employee whom I trusted with administrative and bookkeeping responsibilities. She had access to company accounts, financial records, and sensitive information because I believed she would act with integrity. Like many small business owners, I rely on trusted employees to help carry the responsibilities that come with running a business. Without trust, honesty, and accountability, a small business cannot survive. What makes this situation especially painful is that I genuinely tried to help her. During her employment, Ms. Krause made it known that she was experiencing financial difficulties. Griffin Technology Group's culture is to help our employees, and Ms. Krause was provided with several employee loans and financial assistance, which were properly documented and handled through normal business processes. It is important to me to help Ms. Krause because she needed financial support and a chance to get through a difficult period. I never imagined that someone who had been given such assistance would later choose to steal from the company that had helped her. Ms. Krause's theft is the most painful betrayal of trust I have experienced as a business owner. Given Mrs. Krause's extended period of poor performance resulting in her termination, it was necessary for me to attempt to reconcile the company's books. It was through this effort to correct her mistakes that I first discovered Ms. Krause's theft. I remember sitting in my office, reviewing records and trying to understand what I was seeing. My first reaction was disbelief. I was hoping it was just a mistake. I wanted to believe that someone I had trusted and personally helped would not intentionally do something like this. As the evidence of her theft became clear, I realized that someone I had trusted with access to our business, our financials, had deliberately chosen to take advantage of this trust. This realization was heartbreaking. After Ms. Krause was terminated, we spent countless hours reviewing records, reconciling accounts, gathering documentation, working with law enforcement, and determining the full extent of what had occurred. Time that should have been spent serving clients, supporting employees, growing the businesses, and focusing on the future instead became consumed by dealing with the consequences of her actions. What has been particularly difficult is that the impact of Ms. Krause's actions did not end when the theft was discovered or while working with law enforcement concerning these criminal proceedings. The theft and the resulting loss of productivity to investigate the theft was only the beginning. Incredibly, Ms. Krause had asserted baseless charges against Griffin Technology Group in the Ohio Civil Rights Commission for gender and disability discrimination and had demanded $66,562.50 to settle her claims. Our lawyer provided the legitimate reasons behind Ms. Krause's termination, namely subpar performance and poor behavior, and informed her lawyer, who previously had been unaware of her theft. Ms. Krause, however, has refused our repeated requests to dismiss her baseless claims. As a result, we have spent countless additional hours and company resources and have incurred significant legal fees to respond to Ms. Krause's baseless claims and provide the Civil Rights Commission with the voluminous information it requested. The associated legal fees are nearly 1.5 times what was stolen, totaling over $15,000 as of July 31st, 2026. Ms. Krause's actions continue to have a significant negative impact on Griffin Technology Group and all of its employees. Griffin Technology Group and Vector Aviation are not large companies. They are small businesses made up of real people whose livelihoods depend on the company's success. Every dollar matters. Every dollar lost is money that cannot be invested in employee compensation, benefits, training, technology, business growth, or future opportunities. Your Honor, Griffin Technology Group, myself, and Christina Willie have ventured into a bilateral agreement with Ms. Krause civilly for one reason: to stop the financial bleeding. Ms. Krause was able to make claims against us without merit, basis, or evidence at no cost to her, to attempt to extort additional monies and knowingly bring additional pain and suffering to us all, both financially and in resource expenditures. We have been cooperating with all associated entities at our expense and fighting these claims to the fullest extent possible. It appears that Ms. Krause is not remorseful for her theft, nor does she have any desire to be held accountable for her continued actions. Based on what has occurred after Ms. Krause's theft and termination, we would have pursued civil action against her, demanding attorney's fees which have already accumulated. We are very confident that we would have been favored in any judgments, but our understanding is that Ms. Krause does not have any substantial assets, nor would be able to answer financially to any claims made against her. This bilateral agreement is in no way an acceptance by us for Ms. Krause's previous and continued action, nor do we want it to be considered a pass or consideration for lesser sentencing for her criminal actions. I respectfully ask the court, in arriving at a just sentence, to consider not only the immediate harm caused by Ms. Krause's theft, the continuing harm caused by Ms. Krause's baseless claims in an attempt for further financial gain, and the lasting impact of her offenses and her assertion of baseless claims have had on me, Griffin Technology Group, Vector Aviation, and all of our employees. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. In this case, I know it has been said this is not the most serious form of the offense, and in the sentencing memorandum, it did indicate this is less serious than the average theft or tampering with records. The state would disagree with that. First of all, often in a theft case, it is a one-time theft, and often from somebody that you don't even know, out of a store and things of that nature. This was an ongoing theft of those 3 specific loans on May 22nd of 2025 for $2,500, July 11th of 2025 for $1,500, and August 14th of 2025 for $2,500, not to mention the almost $4,000 that the defendant received and put into the system for Vector Aviation that was never then deposited.
Hold on. This $3,900 and some odd dollars in cash, what was that all about?
I'm just going to say that I did take the money, and I am admitting to that.
Okay. So how did you how did that transpire?
It was in the bank bag in the office, and I just took it.
That was given to you to deposit, right?
Yes, correct.
Okay, tell me everything, not some things. Tell me everything. How did it come that you were in possession of that? Exactly how?
Paul would bring it to the office, and I would put it into the system, and then it would be booked into Sage, and then I would put it in the cash bag, and then it would be there just sitting, waiting for a deposit to go into the bank, but that's not what happened. I ended up just taking it.
Who was responsible to deposit it?
It could be me for deposit, it could be John Griffin, but normally it would be put on me to deposit.
Right, so you entered it into the system indicating
that it was just in the office, waiting for deposit.
And then what? When was it?
I mean, any time he brought a cash deposit, so it could have been, I'm not sure. Like it could have been a random Tuesday. I'm not sure. Like it could have been any day of the week. I mean, Paul would just come on a random day and bring a white envelope.
So if you enter it into the system, that it is to be deposited, how is it ever verified that it's deposited in the system?
There would be a date next to Sage. We would match it up to Flight Circle.
To what?
There's a system called Flight Circle where they would show that money was taken by a client.
Okay. So when you entered this into the system, you said it was entered in as to be deposited.
Yeah, it would show like it would show like a cash deposit.
Right. It showed a deposit, right?
Yeah.
That never occurred.
Mm-hmm.
Okay.
Yes, that is correct.
Go ahead, Ms. Cutts.
Thank you, Your Honor. So this was ongoing activity during the years that the defendant was working there in 2025, specifically, so both at Griffin Technology Group and then also for Vector Aviation. In addition to taking that money, she already had a loan that had been approved that she was paying back on. However, she stopped those payments through the system, so they were no longer automatically taking the money out of her paycheck to pay back the loan that was in place. So she manipulated multiple systems. There was a system that they no longer used, which is where she documented some of these aspects. She would put untrue reasons or explanations in as to why money was removed. So she did go into their records, which is why Mr. Griffin, when he was going through, found those discrepancies of where money was and hadn't gone. So we have a situation of an ongoing theft, ongoing behavior, which would make this more serious than the average theft as opposed to less serious. Also, the victim obviously suffered psychological and economic harm. Mr. Griffin said it better than I ever could, how it has affected him, his company, and the relationship that he had with the defendant, as well as the economic harm, the actual money taken, as well as all of the issues that have come since this has occurred that have also cost the companies money. That being the actual money taken, that effect is the $11,133.67. And then, as Mr. Griffin has indicated, there have been a lot of expenses separate from the actual theft that have created more expenses and more concerns for them, as well as the time to go through everything and to fix everything to make sure all their documents, all their systems have the correct information so that he can go forward. As he indicated, there was that claim of discrimination that made an initial demand of over $66,000 that just continued to linger on, making them have to, Griffin Technology Group, have to deal with all of those issues while the defendant didn't have to do anything. So the betrayal that he has portrayed is clear and understandable based on the fact that she worked there about 3 years. So her occupation facilitated the offense. She did the payroll. She had access to the different accounts, the different systems, the money. The relationship with the victim facilitated the offense. She was his employee, had been there multiple years. He had been attempting to help her in ways that he could, but through documentation. There were statements that she showed genuine remorse. The state doesn't normally make too many comments on that aspect. However, in the pre-sentence report, as this court is aware, she tried to deflect and not take full responsibility or full blame for it, trying to indicate that, somehow implying that giving her so many loans was somehow victim's fault, as well as that she thought he knew when she knew in reality that that was not what was occurring, and just taking advantage of the situation and her knowledge from that workplace. There were arguments in the memo that recidivism is unlikely to recur. The state would take exception with that as well. She doesn't have an extensive criminal history, but in 2016 she does have a conviction for identity fraud out of Geauga County that entailed her opening up a credit card in a quasi-family member, her children's paternal grandmother's name, using that credit card. She was caught when she tried to get cash advances. So there's some similarities of taking advantage of people she knew and trying to get money from them without their knowledge. And in the pre-sentence report, there were just a lot of statements, as I mentioned, about thinking that he knew, but she used the old payroll system. She already had the outstanding loan, and the lack of truly taking responsibility, and then to come into this court and ask to consider her children and her family when she was not considering them in her actions is concerning to the state. So the question comes down to whether she's amenable to community control or not. The state does have its concerns. It does not agree that she takes full responsibility unless and until she is pressed and put into a corner, as opposed to just taking responsibility as the right thing to do. If the court gives her an opportunity on community control, we do think that jail time is appropriate. This was thousands of dollars. She does have a prior felony conviction for similar activity. So we do think there should be a punishment involved, as well as services that may help her in the future. She does have 2 days credit. We would recommend, if the court does do community control, that she enter and successfully complete the NeoCap program, that she also have a full drug and alcohol evaluation and a full mental health evaluation, that she not use any drugs or alcohol and have periodic screens that come back negative. Obviously that includes no use of marijuana as well. That she have one doctor, one dentist, one pharmacy, and sign releases. That she take any medications prescribed only as prescribed. That she engage in full-time work or school. That she have no contact with Griffin Technology Group, Vector Aviation, or John Griffin. That she pay the restitution as agreed upon. All remaining counts would be dismissed, and that she would be made aware of, if given this opportunity, that if she were to violate, she would be looking at up to 24 months in prison. And that would be the state's comments at this time. Thank you.
How many people, when you worked there, were working at Griffin Technology Group?
I believe it was 11 people.
Does that include Vector?
Vector is a different entity at a different building, and
How many were working there?
they're independent contractors, so I feel like Paul would be the main person, and independent contractors maybe 10 to 15.
So 11 people working at Griffin.
Correct.
11,000 stolen total, including the Vector, and a whole bunch of money spent fighting off an invalid claim is a significant impact on a small company, right? You handled the books. Wasn't that a significant impact on that company?
I mean, possibly.
Possibly.
It could be, yes.
Possibly.
But the moment that my attorney stated that he was going to no longer pursue it, I completely stopped. Like, I said, okay, we're done. So I'm not sure what
Yeah, me neither. Me neither. But
John Griffin's attorney was fighting.
But that's beside the point. That's beside the point. All right, I've reviewed the pre-sentence report as well as the previous Geauga pre-sentence report, the psychological evaluation, the victim impact statement. I've reviewed the sentencing memorandum, which included letters in support of you that was filed by Mr. Salem. I've considered all the provisions in 29, 29, 11, 12, and 13. You've got the one conviction in 14 for similar activity, which was essentially a theft by deception. I'm going to find you amenable to community control. I'm going to place you on community control for 5 years. You're going to serve 150 days in a Lake County jail with credit for 2. During a 30-day period which I want to put in the entry is going to be sooner rather than later, like within the next 30 days she entered into the jail treatment program and completed. As a matter of fact, why don't you put in the entry that by September, no later than September 15th, she's to be entered into and complete the jail treatment program. Follow the recommendations.
Do you want it completed by September 15th, or
No.
she has to enter? Okay.
Enter into it, because they're gonna require that she have some period of time that there is no indication of drug or alcohol use. Why don't, as a matter of fact, make that date September 7, okay?
September 7th?
7,
Okay.
yeah.
Thank you.
Upon a filing by Mr. Salem, I will consider work release, continued treatment with mindfully, and follow all the recommendations. Attend at least 3 AA or NA meetings a week and obtain a sponsor. You're to utilize only one doctor, one dentist, and one pharmacy for prescription medication. You're to take your medication as is prescribed and sign releases. No contact with the Griffin Technology Group and any associated companies or individuals. Restitution in the amount of $11,133.67. The amount of at least $250 per month. Obtain and maintain full employment and pay the costs and supervision fees. Ms. Knaus, any other terms you think are applicable?
No, Your Honor, thank you.
Do you understand the terms?
Yes.
Any question about the terms?
No.
If you fail to comply with the terms of your community control, the state will file a motion to terminate. And if I find you violated and I terminate you, you face 24 months in prison. You understand that?
Yes.
Any remaining counts are dismissed. Anything else, Ms. Cutts?
Yes, thank you, Your Honor. Is the community control concurrent for each
Yes.
count? And then I may have missed it. I'm not sure if the court had indicated no use of drug and alcohol with the periodic screens.
We did. I did not. So there's to be no use of drugs or alcohol, and you'll be screened. Mr. Salem, anything further?
No, Your Honor.
All right, we're adjourned.
All rise.
Now solidly, there we go. Now solidly in hour 3 of TCF Live, and I'm energetic, which is weird because I only slept about 2.5 hours last night. So today's going to be interesting, but we have a full slate of programming again for you today. Reminder, we have second session at 2:30 Eastern, 11:30 Pacific, and tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, featuring April Searing, guest panelist, fellow law tuber, will be joining us tonight, so do join us for sidebar. Let's go to North Dakota. Judge Nick Thornton.
Of North Dakota versus Jeremy Geyer, 02-2026 CR 189. Ms. Duffy appears in the Barnes County courtroom. Mr. Geyer appears by reliable electronic means from the Barnes County Correctional Center. Ms. Chisholm appears, making a special limited appearance as a public defender for Mr. Geyer for today's purposes by reliable electronic means. Mr. Geyer, were you present in court when your rights were read?
Yes.
Do you understand your rights?
Yes.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. The law presumes that you are indigent and appoints a public defender for you automatically to handle this hearing only. If you intend to hire a lawyer, you can always hire a lawyer. If you intend to represent yourself after today's hearing, you can request the court allow you to represent yourself, or you can choose to apply for a public defender. But if you want a public defender after today's hearing, you'll need to apply. Do you understand that, sir?
Yes.
Have you received a copy of the charging document in this case?
Yes,
Is your name spelled correctly in that upper left-hand corner of the charging document?
it is.
Am I pronouncing your name correctly, sir?
You are.
All right. You have the right to have that charging document read to you in its entirety, or I can summarize it for you. Are you comfortable with the court summarizing it?
Yes.
The state alleges that on or about or between August 4 and 5, 2026, in Barnes County, you committed 3 criminal offenses. In count 1, the state alleges that you committed the Class C felony offense, terrorizing domestic violence. In particular, the state alleges that you told a former intimate partner with the initials J.M. that one or both of them is going to die tonight, and that you held a knife to J.M.'s throat, causing her fear. Again, as charged, that is a Class C felony. Because you have 2 Class C felony level offenses, I'm going to talk about the penalties for the Class C felonies together. In count 2, the state alleges on or between those same dates in Barnes County, you committed the Class C felony offense, reckless endangerment. In that you inflicted or attempted to inflict bodily injury upon JM, or you threatened or menaced JM with imminent bodily injury with a dangerous weapon, explosive device, or destructive device. And that created a substantial risk of serious bodily injury or death under circumstances manifesting the extreme indifference to the value of human life. Again, that is alleged to be a Class C felony. Class C felonies carry with it a maximum penalty of 5 years in prison, a fine of up to $10,000 or both. Court fees associated with the Class C felony total $525. The state has alleged applicable minimum mandatory penalties as they apply to count 1, the terrorizing domestic violence count, because the state alleges you used a weapon in the commission of that offense. The state has alleged a 2-year imprisonment minimum mandatory penalty with no possibility of parole during those first 2 years. And because JM is alleged to be a former intimate partner, the state has also alleged that you must complete a domestic violence offender treatment program for both counts 1 and 2. The state has alleged that you are required to provide a DNA sample and fingerprints for inclusion in law enforcement's databases. Count 2 carries with it a similar minimum mandatory penalty of 2 years imprisonment. The state has not alleged the domestic violence offender treatment program is necessary or is a minimum mandatory penalty for count 2, but count 2 also carries with it the requirement that you submit fingerprints and DNA. There are other consequences that apply to all 3 counts. I'll talk about that in just a moment. Count 3, the state alleges that on or between that same date, August 4, August 5, in Barnes County, you committed the offense of domestic violence in that you caused bodily injury to JM's wrist, and JM is a former intimate partner, as alleged. That is a Class B misdemeanor. Class B misdemeanors carry with it a maximum possible penalty of 30 days in jail, a fine of up to $1,500 or both. Court fees associated only with count 3 total $250. The state has alleged, because JM is an intimate partner, that you complete a domestic violence offender treatment program as a minimum mandatory penalty for count 3, and that you submit fingerprints for inclusion in law enforcement's databases. For all 3 offenses that you're charged with, sir, if your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, a conviction of any of these offenses can result in significant adverse immigration consequences for you. And they might also carry with them significant adverse collateral consequences that the court is not required to explain. To understand the nature of the charges and penalties as I've read them.
I do.
Do you have any questions about the charging document?
No.
All right, because you're charged with a felony, I'm not going to take a plea today of any kind. Instead, that decision will happen at a later date after a preliminary hearing. So the only issue that's left is the issue of determining bail. I'm going to hear first from the state, and then I'll hear from Ms. Chisholm on her thoughts about bail, and then I'll hear from you, sir, if you wish. Go ahead, Ms. Duffy, tell me your recommendation on bail. Ms. Duffy, I can't hear you.
Sorry. In this case, Your Honor, the defendant appears to be primarily from the New York area. His criminal history begins in 2005 with criminal mischief, 2007 coercion, threat of physical injury, 2008 contempt in the second and disobeying a court, 2009 harassment in the first, 2009 criminal mischief with intent to damage property, 2009 felony criminal contempt of the first degree, 2011 felony criminal contempt and a first violation of order of protection, 2014 aggravated harassment of the second degree, 2017 criminal mischief with intent to damage property, 2023 felony strangulation of the second with obstructing breath and blood circulation causing physical injury, 2023 resisting arrest. In the III, it states that this was listed as covered by another charge in the disposition section. 2025, there's two listings. One is burglary in the second degree, illegal entry of a dwelling. That one might be pending. It doesn't have a disposition, and based on it being a 2025 case, I would be surprised if it was disposed of by now. Also a separate 2025 criminal mischief with intent to damage property. Also seems, I think it might be pending. The defendant does, he's been in jail on a different file. He does talk on his texter about wanting to go home and turn himself in. I'm not sure if that's for a pending charge or for a warrant that's not hitting out, but either way, it appears to be for court in New York. He also talks about trying to make money to get home. So again, the state submits that the risk of flight continues to increase. I would recommend that bond in this case be set at, in this case only, in the amount of $7,500 cash, or in the alternative, a $30,000 surety, with additional conditions including that there be a no contact order with JM, no possession of weapons, no leaving the state without permission from the court, and the standard conditions that include being on a drug patch as during his contact with law enforcement, they believe that he was under the influence of methamphetamine due to his behaviors.
Ms. Chisholm.
Thank you, Your Honor. Mr. Geyer has a bail order out of court file 0226 CR 185 in the amount of $5,000 cash or surety in the amount of $15,000. We would ask the court to join that bail order with this current court file.
Was he out on bail when this offense happened?
He was not. This offense occurred prior to the offense identified in the previous case, judging by the dates alleged, Your Honor. August 4th and 5th are alleged in this current case. In the prior case, it looks like it was August 11th that was alleged.
All right, thank you. Mr. Geyer, I will inform you that you have the absolute right to remain silent. If you choose to remain silent, your silence won't be used against you in today's hearing or any other hearing. If you choose to give me a statement, sir, I want you to understand that doing so, in doing so, anything you say can and will be used against you. These are recorded proceedings. The prosecutor can get a transcript of today's proceedings and use any statement or admission of fact against you in later proceedings. Do you understand the court's warning, sir?
No.
I'm sorry, I didn't quite understand you.
I do.
Do you have anything you want to tell me before I make my bail decision, sir?
No.
All right. Court is going to set bail for the time being at $5,000 cash. Or on the alternative, $15,000 corporate surety. Additional conditions. Defendant to remain law-abiding. Defendant not to come within 300 feet of JM, nor have any contact with JM directly or indirectly, except through law enforcement or an attorney. Since you've been charged with a crime of violence or a threat of violence, stalking, harassment, or a sexual offense, any violation of the court's no contact provision constitutes a separate criminal action or a separate crime. It is a Class A misdemeanor punishable by up to an additional 360 days in jail, a fine of up to $3,000 or both. If law enforcement determines that you have violated the court's order and that the law enforcement officer has probable cause, the officer must arrest you whether or not that alleged violation occurred in the officer's presence or not. The prosecutor must give a copy of this order to JM. You shall not leave the state of North Dakota without the advanced express permission of the court. You must, well, sir, what's your plan for counsel? Do you plan on hiring a lawyer? Do you plan on applying for a public defender?
I need a public defender.
All right, you're going to be required to complete a public defender application before release. If a public defender is appointed, you must maintain at least weekly minimum contact with that attorney. You must notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. You shall not use or possess alcohol or controlled substances unless prescribed. You shall not possess a firearm or other dangerous weapon. You must sign a promise to appear and waiver of extradition before release. You must personally appear for all scheduled court hearings in this matter. Your next court date, that preliminary hearing, is scheduled for September 10, 2026 at 1 p.m. in the Barnes County Courthouse in Valley City, North Dakota. You must submit DNA and fingerprints before release. Understand the court's bail order, sir?
I do.
And this is not consolidated with the other file. This is a separate bail, so you'd have to post bail in both cases before you would be released. I want to make that clear for everyone involved that at this time I am not consolidating bail. So those bail orders remain separate. If you remain in custody for longer than 48 hours following today's hearing, you have the right to request a bail review. Do you understand your right to request a bail review?
Oh.
All right. With that, we are adjourned in this matter. Thank you.
Friends, I told you in the chat that I smelled food. Compliments of Grandma TCF. I've got some scrambled eggs with some ground turkey topped with some cheddar cheese. Thank you, Mom. I appreciate that. So I'm going to eat through through the next hearing here. Let's go to... Oh, golly geez. Let's go to Michigan. Judge Aquilina. Let's see what's going on there.
This is docket 26-3500FH. People of the state of Michigan versus Robert Joseph Almazan. Thank you. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Jonathan Foreman for the defendant Robert Almazan, who stands to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Ms. Donnelly, will Mr. Foreman be here for the sentencing then?
Your Honor, it'll either be, I intend to be here for the sentencing because I'm here for the plea, but if in the event that I can't be able, I will find coverage for it, but I intend to be here.
Okay, I just was gonna ask, is it all right if you have two separate attorneys, or would you like Ms. Donnelly to be here for the same spot?
Well, I'm dealing with Jonathan Foreman, but she's here today, so.
So are you okay dealing with both of them?
Yeah.
Okay, we just need to make a record of that. All right, thank you. And sir, do you still reside on Doreen Drive?
Yes, sir.
And have you taken any medication yesterday or today?
Just
I don't need to know what, I just,
No.
so it's nothing that would
Yes.
affect your ability to understand your attorney or the court?
No.
And is there medication you're supposed to be on that you're not on? Any sign of fever, COVID, or other illness?
No, ma'am.
I understand there's going to be a plea today,
Yes.
and you made that decision after talking with your attorney?
Yes.
And no one forced, threatened, or coerced you into making this decision?
No, ma'am.
Other than the plea agreement, no one promised you anything?
No.
And you've been satisfied with the representation of both Mr. Foreman and Ms. Donnelly?
Yes, I am.
All right, thank you. And what you're pleading to, were you on probation, parole, or bond conditions at the time?
I believe so, yes.
Another file, or are you talking about pretrial services?
I'm not exactly sure, Your Honor. It is a very old file. This happened in 2019, I believe. I don't have any record though that he had done a probation violation in our county.
Okay.
I don't see one in our county either.
Okay, why is this so old?
There was a period that he was in bench warrant status for several years.
Okay. Okay, just making sure we didn't drop the ball somewhere. Okay. And what is the plea offer?
Yes, Your Honor, the defendant will be pleading to count 1, operating while intoxicated, third offense notice, and count 3, felon in possession of a firearm. Upon successful plea and sentencing, count 2, carrying a concealed weapon, count 4 and 5, felony firearm, count 6, carrying concealed while under the influence, count 7, driving while license suspended, and habitual second will be dismissed. There is also an agreement to county cap at the time of sentencing, and any restitution to be determined at the time of sentencing.
Full, fair, accurate, and complete?
Yes.
Full, fair, accurate, and complete?
Yes.
And counsel, you're waiving reading the habitual second along with counts 2, 4, 5, 6, and 7?
Yes.
As to reading of felony information, counts 1 and 3.
Yes, Your Honor. People of the state of Michigan versus Robert Joseph Almazan. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, operating while intoxicated / impaired, third or subsequent offense notice. On or about November 8th, 2019, at Lake Lansing Road and Harrison Road, City of East Lansing, Ingham County, State of Michigan, the defendant did operate a vehicle upon a highway, Lake Lansing Highway, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to statute. While that is typically a misdemeanor, there is a third or subsequent offense notice, which makes it a felony. Take notice that the defendant was previously convicted of operating while intoxicated on or about July 23rd, 2013 in the 55th District Court, and of operating with a high VAC on or about January 4th of 2012 in the 56th District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under statute and vehicle forfeiture per statute. This is a felony that has gone up to a maximum of $500 to $5,000 and either 1 to 5 years or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service, rehabilitative programs per statute, cost of prosecution, reimburse government for emergency response and expenses for prosecuting defendant, see statute, mandatory vehicle immobilization for not less than 1 year or more than 3 years, see statute, unless the vehicle is ordered forfeited under MCL 257.625N. A term of imprisonment imposed must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. Count 3, weapons, firearms, possession by felon. On or about November 8th, 2019, at Lake Lansing Road and Harrison Road, City of East Lansing, Ingham County, State of Michigan, the defendant did possess and transport a firearm when ineligible to do so because he or she had been convicted of a possession of controlled substances, delivery and manufacturing, cocaine, heroin, or another narcotic less than 50 grams, a specified felony, and the requirements for regaining eligibility had not yet been met, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $5,000 with mandatory forfeiture of the weapon or device per statute. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand operating while intoxicated, third offense is a felony punishable by 5 years. There's the enhancement because the first one's 93 days, the second one is 1 year, and it's a third or subsequent offense, so it now is the 5 years. Do you understand that?
Yes.
And also the count 3 weapons, firearms possession by a felon is punishable by 5 years, and there will be mandatory forfeiture today of all contraband, including any weapons and ammunition. Do you understand all of that?
Yes.
You also can be responsible for the cost of arrest and prosecution, etc. And we'll determine that at sentencing. I don't know if there was an accident or if there's anything else that's due, so we'll talk about restitution and cost recovery at the time of sentencing. Do you understand that?
Yes, ma'am.
And what I just told you about restitution and also forfeiture goes to all counts, not just the pledged 2 counts. Do you understand that as well?
Yes.
All right. And what's the status of that vehicle? I know it's been some time, but.
I still own it.
Okay, so under the statute, it will have to be immobilized or sold.
Yeah, it's in the shop right now, so it's in the dealership getting fixed, so.
Okay, well, per statute, we'll have to deal with that. All right, thank you. It looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
And did you understand what you read?
Yes.
If you had any questions about your rights, was your attorney able to answer those?
No.
You didn't have any questions?
No, I don't. Oh, yeah.
So the way I asked it and you answered it, it would seem like she didn't answer your questions.
No, she did.
She answered your, yeah,
I misunderstood, I'm sorry.
No, it's not your fault. It's frequent that happens, but you didn't have any questions, but if you had any questions about anything, she's answered them so far. Is that correct?
Yes.
Do you have any questions about your rights at this court?
No.
Sir, as to count 1, operating while intoxicated, impaired, third or subsequent offense, how do you plead?
Guilty.
As to count 3, weapons, firearms, possession by felon, how do you plead?
Guilty.
And sir, do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals.
Yes.
You're also giving up your presumption of innocence, your ability to cross-examine witnesses and evidence, your ability to hold people to their burden of beyond a reasonable doubt, the ability to provide a defense, etc. You understand all of that?
Yes.
All right. And has anyone told you what I will do at sentencing? Has anyone told you what I will do at sentencing?
No.
Because I don't know. I don't know much about your case, but I will decide when I'm fully informed. Do you understand that?
Yes, ma'am.
There's also an agreement that there be a county cap at the time of sentencing, which means no more jail. It could be 0 to 365 days. But if I sentenced you to prison, I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes, ma'am.
All right. Thank you. And you also understand, although this says county cap at the time of sentencing, that there is, because it's an operating while intoxicated third, there is a mandatory jail time of 30 days. If I put you on probation, 30 days to 1 year in jail. And we'll talk about that at sentencing. At least 45 or 48 hours would have to be served consecutively. So we'll talk about how that works.
Yes, ma'am.
Okay. How long have you been incarcerated now?
I think 86 days.
Oh, all right. So we've already met that. Okay. Thank you. Sir, did these offenses occur on or about November 8th, 2019?
Yes, ma'am.
In the city of East Lansing, County of Hingham, State of Michigan?
Yes, ma'am.
At a specific location known as Lake Lansing Road and Harrison Road, you came in contact with law enforcement?
Yes, ma'am.
Had you been operating a motor vehicle
Yes.
on a public road or highway?
Yes, ma'am.
You would agree that Harrison and Lake Lansing is a public road?
Yes,
And you had consumed alcohol prior to entering that vehicle?
I did.
Do you recall what you had consumed?
A few drinks.
Okay.
Oh, liquor.
Liquor, okay. And you would agree with me that had you not consumed alcohol, you would have driven better?
Yes, ma'am.
And you were stopped because of your driving, is that correct, or was there an accident?
No, there's no accident, just pulled over.
Okay, and then when officers came in contact with you, did they ask you to step out of the motor vehicle?
Yes, ma'am.
Did they ask you to perform the field sobriety tests?
Yes,
And did you do those?
I believe so.
Did they give you a breathalyzer at that time, or did they take you to the station and do a test on the dead mask?
I think they did it at the station. It was in
Okay.
East Lansing.
Okay, and so you weren't very far from there, so they took you to the station, and you recall the reading of that? Counsel, do you have it?
I do, Your Honor. Here.
0.12.
And counsel, you're not contesting that that is above the legal limit?
No.
So you understand that was above the legal limit?
Yes.
All right, and you had previously been convicted of operating while intoxicated on or about July 23rd, 2013 in the 55th District Court?
Yes, ma'am.
And also on or about January 4th, 2012 in the 56th District Court?
Yes, ma'am.
So you would agree that this is at least your third operating while intoxicated?
Yes.
All right, and at that time, you also had a firearm in your possession, is that true?
The third offense?
No, just, well, during that stop, you also had,
During that stop.
The last one, yes, I did.
okay, so did you give officers permission to search your vehicle?
I believe they towed it.
Okay, and so when they subsequently searched your vehicle?
Yes.
They found a firearm in there?
Yes, ma'am.
Do you recall what kind of firearm it was?
380.
Okay, and it's fair to say you didn't have a license or special permission or authority to have that in your possession,
No.
is that correct? And that's because you had been convicted of possession of a controlled substance, delivery, manufacture of a controlled substance less than 50 grams?
Yes.
And the time had not yet passed where you could apply for carry license, correct?
Yes.
Okay, and you had placed that weapon in your vehicle?
Yes.
And it was under your control?
Yes.
Do you remember where it was located?
It was in council.
Okay, thank you. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
Counsel?
No.
Thank you. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No.
Court complied with the court rule?
You have, Your Honor.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, counts 1 and 3 will enter. Counts 2, 4, 5, 6, 7, and the habitual second are dismissed in their entirety, and count 1 will enter as the OUI third. Any outstanding warrants related to this file, if any, are hereby recalled and dismissed. All weapons and contraband are hereby forfeited. And as to the vehicle, it will be immobilized pursuant to the statute, and we'll talk about that in sentencing. Counsel, I'm sure you can have that conversation with him. All right, do you have a sentencing date?
September 30th at 10 o'clock a.m.
Okay.
All right, sir, are you employed? What's your status?
Yes, I'm a business owner.
What do you do?
Paint and flooring.
Okay.
Your Honor, and just to clarify, I don't know if I missed it, did you forfeit all weapons and contraband?
Yes.
Okay,
It just
thank you.
So what have you been doing? You've been gone for what, 7 years? What have you been doing during that time?
I went to Texas for a little over a year and didn't work out. So I kind of came back and sobered myself up and started a business.
So how long have you been clean?
It was 4 years. It was right after COVID. And then I had a relapse on January of 25th. And then that was a 4-day. And then I've been clean since.
So you're going to AA, NA, CA, what are you doing?
I signed up, I'm doing seeking safety, restorative justice. I did, signed up for MRT. And then I tried CATS, but they said I didn't meet the criteria.
Okay, and so do you still live on Dorian Drive?
Yes, ma'am.
Okay, and who lives there with you?
My wife and my
Okay.
kids.
So is intent to keep him in lockup or to release him?
The concern that we have, Your Honor, is that obviously this case is from 2019. He FTA back in 2019, and then never mind. He FTA back in 2020, in January of 2020, and only showed back up now. So the people are just concerned that he would be a flight risk if he is let out prior to sentencing.
So was he picked up on a bench warrant or did he turn himself in? Sir, what'd you do? Did you turn yourself in or?
No, they pulled me over.
So why did you forget about us for so long? I mean, you may have this.
Like I said, I was just trying to get my life back together. And I was eventually gonna, when I got my money right and everything, come in. Right now, my business is kind of struggling, so I was hoping for a bond reduction.
And it is correct, Your Honor, I just wanted to put on the record that I don't see his family here today, but they were here yesterday, his wife and kids were.
Yeah, she couldn't make it.
I don't care if the whole fleet shows up. I care about you showing up.
Yes,
Does it
ma'am.
mean anything to me that your kids can see you in that prison guard or jail? I don't think that's good for kids to see. But good that you have their support, but you should have cleaned this up in 2019.
Yes, ma'am.
Any alcohol in your home?
No.
Any weapons in your home?
No,
Any felons in your home?
no, just me.
All right, so I'm giving you a $50,000 PR bond to report to pretrial services as directed, no less than weekly. You are going to be placed on a scram tether, and that's so we can make sure you're not using any alcohol. So you need to plug that in, not obstruct it, follow those rules, and then we'll talk about how long that stays on at the time of sentencing. See how well or how poorly you do. You shall not use, possess, consume purchase, or be in the presence of any illegal drugs, alcohol, drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, or your wife. I don't see the need for regular testing because you'll have that scram tether on, but if somebody wants you to do a test, you will do that. You will not have in your possession, under your control, or in your presence a weapon, gun, ammunition, imitation of a weapon. You will not use any object as a weapon. You will maintain your current residence, and any address change will be reported to pretrial services, the court, and your counsel within 24 hours. Your next court date is September 30th at 10 a.m., and you will submit to a substance abuse assessment and complete the pre-sentence investigation report with probation. Counsel, I don't care if you want to send them over to Pat's for the assessment, or probation does it, or however you want to do it. I just want to make sure he's handled whatever's going on, and maybe he just needs aftercare, maybe he needs something more intense, I don't know. Sir, you will need to come back to this building within 24 hours, go downstairs, just hit G on the elevator, go downstairs, probation's down there, make and keep an appointment. You can also call them, it's on the purple sheet we're going to give you, and I'll write the number on the sheet as well. Their phone number is 517-483-6100. However, sometimes it can be difficult to reach them over the phone. You must make an appointment. You must keep that appointment. If you do not, then I can't get to sentencing. They're going to do a detailed report. If you forget about doing that, I simply have you arrested. You'll sit in that jail a few more months until they decide to come see you. That's up to you.
So this is something I can do tomorrow morning?
Yes.
Okay.
Anything further?
No, Your Honor, thank you.
No, thank you.
Thank you. Good luck to you, sir.
Alrighty, friends, about 10 minutes or so to go with TCF Live here this morning. Reminder, though, we do have a full slate of programming today. We have second session at 2:30 Eastern and sidebar at 8 p.m. Eastern, so do join us for those. Let's go to Texas. We haven't been there yet today. Let's pick up a hearing or two with Judge Stevens before we call it a morning.
Yes.
With your attorney, Ms. McNally, and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about October 19th, 2025 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger. I'm going to need a pad for all of this. This is under a child passenger under 15 years of age. Do you understand what you're charged with here, ma'am? Yes. All right, she's got to take it down. You said yes? Yes, sir. Okay. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement has been reached in your case where you would be pleading guilty, found guilty, sentenced to 2 years in the state jail. That would be suspended and you would be placed on regular probation. I'm going to circle years for 5 years.
Yep.
And then $500 fine. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal. Do you understand that? How do you plead to this charge, ma'am? Guilty or not guilty? You have a soft voice.
Guilty.
Are you pleading guilty voluntarily and
Yeah.
because you are guilty?
Yes.
I'm going to show you what's Multiple States Exhibit 1. Did you sign that document, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
States Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes.
States Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here?
Yes.
I'm going to follow this agreement with nothing further to add. I'm going to find then that, Ms. Edwards, you are pleading guilty today voluntarily. You are mentally competent to do so. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this story. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement shall be suspended. You were placed on regular probation for 5 years. There will be a fine of $500. There will be terms and conditions of probation, which include completing a DWI education course. And that's a good thing. That'll help your insurance. And then the probation officer is going to go over all of these with you. There are some 36 conditions of probation, but the overwhelming majority of those are conditions of probation or conditions of life that we all follow. Number one, don't commit an offense. Okay. 2, don't associate with disreputable people. These are all great ideas for everybody. Don't properly support dependents. Don't use or possess illegal drugs. Dress appropriately. Some of this, but many, actually, a majority of these things, all of us should follow. So it's a blueprint for great behavior and fixing this mistake and moving on and being the best person you can be. Do you understand what has happened today?
Yes, sir.
Anything else to add by anybody?
No, Judge.
Okay, thank you. Please see the probation officer. There is no minimum.
That's correct.
For that, which is an ironic thing under the law.
It's an oversight.
Yeah, because for the same event, if it's not a child passenger, if you're just a DWI, you got to just serve 3 days.
For a second.
For the second one, but you would think a child has more of a level of points. It's okay. Daryl Jones. Who's this? Thank you. 26 CR 638 is called, and you are Daryl Jones?
Yes, sir.
Daryl Dwayne Jones. Here with Ms. McNally, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about November 5th, 2025 in Jefferson County, Texas, in cause number 26 CR 638, it alleges that you, Daryl Dwayne Jones, committed the 3rd-degree felony of tampering or fabricating physical evidence with intent to impair it. Let's see. Knowing that an offense had been committed, namely deadly conduct, you intentionally or knowingly concealed a firearm, namely a handgun, with intent to impair its availability as evidence in an investigation or official proceeding. Do you understand what you were charged with here?
Yes, sir.
If convicted of a 3rd-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500, and there would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily?
Yes,
that
sir.
is on your own free will, and because you are guilty of what this alleges.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand?
Yes, sir.
Discuss it with your attorney. Are the contents true and correct? Yes.
Yes, sir.
State's Exhibit 1 tendered into
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand what you're charged with? The indictments have been read to you. You've read it. You're guilty of the crime charged and any less included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation by your lawyer. All true, this states, so help you God. States Exhibit 1, part of the record for all purposes. Your sentence report is waived.
Yes, Judge.
I'm going to follow this agreement. I'm going to find that you are mentally competent to enter this guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on for or unadjudicated probation for, this is a third-degree felony. It's up to 10 years. What are we doing? Lawyers.
I'm agreeing with Ms. Madaldi's suggestion for 5 years, Judge, specifically because he admitted his conduct right at the scene whenever this was charged. In his early acceptance here, we feel like it's appropriate.
I don't think so. I think it's more than appropriate.
We can do less than 5, Judge, if you are feeling generous.
We're going to place you on deferred and adjudicated probation for 5 years. You do well, it'll be shortened to 1/3 of that, which is 1 2/3. How's that? But what you apparently did was own up to it like a responsible person. You made a mistake. You fouled up. You fixed it. You're fixing it. That's what we do. We all make mistakes. It's how we deal with the mistakes. That's the test of character. You're going to be fined $500. And again, I don't know if you were here before, there's a lot of conditions of probation, but they are the blueprint that we have to follow every day. Everybody ought to sign off on this in the world, and we'd all have a better place to live in because it is a blueprint of good behavior, living peaceably with others, and not committing crimes. The probation officer will go over with you on all of this. Here's the deal. There's a lot riding on this for success. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 10 years in prison. So you're going to do well?
Of course.
Good. Please see the probation officer. Thank you.
Thank you, Randy.
Thank you.
Alrighty, friends, that will do it for this morning. I hope you enjoyed the show today. I did. I thought we had a lot of really good court today. But we're not done. We'll be back for second session at 2:30 p.m. Eastern and sidebar tonight at 8 p.m. Eastern. So do join us for those because we'd love to see you there. The wisdom I leave you with this morning is from Eleanor Roosevelt. In the long run, we shape our lives and we shape ourselves. The process never ends until we die. And the choices we make are ultimately our own responsibility. If we could only get that through to some of the people that we see in court, they would probably be much better off. Alrighty, friends, enjoy your day. Hope to see you in about 2.5 hours. Take care. God bless.